and 10, Lordship.
9 and 10.
Lordship, yes, Lordship.
Part heard.
Yes, Lordship. Lordship, the Mr. P. Nayak, Lordship, because of some personal.
Who is having personal problem?
Lordship, Mr. P. Nayak, he's out of station, Lordship. Lordship, seeking a short accommodation.
Mr. Mohanty, you are appearing.
I am appearing on behalf of honorable respondent, my lord. Our part is already completed, my lord. Only the record has to be produced by the government council.
By the
Nayak, Mr. Nayak is very important, my lord.
Mr. P.D. Nair.
P.
Nayak.
Lordship.
He has to produce the records. Was there an order for that? For
Yes, sir.
production of
Probably
records?
there is a order. Yes, there is a order.
In item 8, items
9 and
9 and 10. Order,
9
order,
and 10. Mr. A. Chalia, learned counsel, for respondent number
Lordship, Finance Department.
for the finance, learned standing counsel, finance, submits that Mr. P.D. Nayak, who is handling the brief on behalf of the finance department and who was supposed to produce the records, is out of station today and accordingly seeks accommodation in the matter. Prayer is not opposed. Relist.
Lordship.
25th, Your Lordship.
My lord.
All right. Interim, anything is there?
Then, Your Lordship, let it be on 27th, Your Lordship.
27.
No, there is no entry.
All right.
27th.
27 March.
Lordship.
My lord.
Yes.
Okay. Okay. Yes, please.
Thank you, Lordship.
Yes, Mr. Sharma.
Probably, Your Lordship, over item number 25. I just need accommodation for the day, Your Lordship. My
20.
25, Your Lordship. Item number 25.
You are for the,
For the petitioners, Your Lordship.
have you informed the
Yes,
other side?
yes, Mr.
Respondent.
Yes.
You are for the
Yes,
respondent. Mr. P. Sharma.
M. Sharma.
M. Sharma, learned counsel for the petitioner, seeks accommodation for the day
Yes.
with consent from the other side.
Yes.
Prayer is allowed. Relist.
I'll leave it to Your Lordship's convenience.
Next week, other date did you?
First, there's an interim in our favor. Your
Interim, if any, shall continue till the next date of listing. Yes, Mr. Banik.
Wait, please, Your Lordship. Well, I need to reconstruct item number 15. Gentleman who had engaged me in the matter, he's in South Sharmara now. So the file is not there.
Item 15.
1-5.
Mr. S. Banik, learned counsel appearing for the petitioner, submits that due to the file having been misplaced, he requires some accommodation in order to reconstruct the records. Prayer is not opposed. Who is for the other side? Prayer is allowed. Relist on such and such date after April or 2nd after Bihu Didya.
After we could be 22nd of April. I'm grateful, my lord.
Yeah.
Obliged.
My lord, need
Yes.
to mention for item number 20 of today's list.
Item number?
2020.
Yes. What do you want?
Actually, thing is that the case has been listed long after 5 years. So in between, sorry to say, so we have misplaced some of the important statements, you know. So
You are for the petitioner.
I'm from the respondent number 2.
Who is for the petitioner?
Petition is a state.
Hmm?
It's a state versus
No, there are item 20.
item 20.
20 is, you are for the petitioner or
The
respondent?
respondent number 2.
No, petitioner, Mr. Bora is appearing.
Yes.
Have you taken his consent?
Yes, Mr. Bora only sent me over.
Have you taken his
Yes,
consent?
right, my lord. Yes, my lord. He has.
Are you sure?
I'm sure. Rinku Hazarika and Mr. Bora are senior counsel.
You have taken their consent?
Right. They have only sent me through WhatsApp and all.
Your name?
My name is Shubhashish Das.
Mr. S. Das, learned counsel appearing for the respondent number 2, submits that due to the matter being
Listed after long 5
since
years.
the matter has been listed after a long time of 5 years.
5 years.
After about 5 years, comma, some documents has been misplaced in the meantime and accordingly seeks accommodation with accommodation.
Any
Stop.
appropriate days you feel it comfort.
Prayer is
Next week.
Prayer is not opposed. List.
Third. Obliged.
May I please, Your Lordship? With respect to item number 16, Your Lordship, I'm appearing on behalf of TD, Your Lordship, amicus curiae.
Yes.
The court may kindly directed the court to, we
I
have not,
cannot hear you, ma'am.
sorry, Your Lordship. We haven't received the paper book yet.
You have not received.
Yes, Your Lord. 16.
Item number?
16, Your Lordship.
No,
On
fine.
6.
Have you received?
Lordship,
Have you received the paper book?
yes, Lordship, I'll still receive it.
The paper
No
book I
paper
don't
book,
think is
no.
prepared here.
No, not here.
Though by order dated 6/1/2025, this court directed the registry to furnish the relevant papers to Mr. T.R. Deori, learned amicus curiae. However, today when the matter was called MS,
L Wangsa, Your Lordship.
MS,
L Wangsa.
L1,
Wangsa.
Wansa, learned counsel, appearing on behalf of Mr. T.R. Deori, learned amicus curiae, submits that that no relevant papers has been furnished to the amicus curiae till date. Stop. Let registry do the needs. Let registry furnish the relevant papers to the amicus curiae. Stop. List in the third week of April. Third week to Kulasana? Third week of April for hearing.
Obligation.
For admission, item number 1.
You have, Mr. Sharma, you have submitted your written arguments.
I also submitted, my lord.
This is
Just-
security deposit
Yes,
too.
yes. Just I want to, my lord, refresh this honorable code on our stand, my lord, that I have reflected in our region.
Yes, please, Mr. Gogoi, just refresh my
Lordship.
memory as regards the facts also once.
Now here, my lord, it pertains to 2 contracts, my lord. The petitioner has completed the 2 contracts. But my lord, there is another part, apart from my lord construction, that my lord, he will have to maintain the, my lord, routine maintenance of the work for another 5 years from the date of completion of the work. That has been defined in the, my lord, contract. And my lord, for non-performance of that, my lord, routine maintenance work, an amount was deducted from the security deposit of the petitioner, which according to the petitioner, we could not have done, because that security deposit can only be deducted for, my lord,
The entire
Effect-
security deposit was deducted or some part?
balance amount is there, we can, my lord, release that, my lord, immediately, my lord, order is passed by the honorable court. That we have reflected in our affidavit, what is the amount now due after deduction.
So the issue is whether whether for non-performance of the routine maintenance,
Yes,
can the money be deducted from the
security deposit.
security deposit? That is the issue
Yes, the
which has
stand
to
of
be
the petitioner
determined.
is this, my lord, the security deposit can be tasked only in case, my lord, if the defect
According
like.
to Mr. Das, if I remember, he says that there is nowhere,
Provision.
there is no provision in the contract which
Lordship.
permits deduction of security deposit
My lord.
in connection to routine maintenance. However, you had, I think, in 2 places, some 2 clauses indicated that,
yes. My lord, that I would like to point out.
yes.
So, Lord,
Mr. Das, I just wanted the facts to be refreshed. Since you were not here, he started. If you want to refresh it, you can do it.
Absolutely, there is no problem.
All right.
The only what I say that this is the only narrow campus,
yes,
whether my security amount.
Correct.
which is
That's
lying
what
with
I
them,
said. That is the issue for
that's the issue,
determination.
whether from routine maintenance, they
So
can.
basically now, you both will show it from the contract. You will say it is not there. He will try and show that it
But-
is there. So then the court will have to ultimately
yes, the
look at
clauses are
the
same, my lord.
clauses. If the clauses are clear,
See.
intentions are clear, then this is not
But
the
yes,
part
but
of the
right
court
now,
to go into it
There
and
has to be.
read something which is not there.
Has to be a part of the contract.
Correct.
Now,
correct.
my lord,
So that's why I've
my-
indicated that.
now the coordinate bench already has decided this issue about routine and bench. Now, suppose your lordship now wants to defer this particular judgment, then it has to be placed before larger bench.
That is only
That's-
if this court wants to defer.
Therefore, wants to court, because there are judgments of 2 judgments.
Which are the 2 judgments of the
Yes.
coordinate
Oh,
bench?
judgment to some-
Have you given it?
Yes, yes,
Here.
we have mentioned that also.
Please give me.
If we reply, we have filed. If your lordship will like to see, affidavit will reply at page 146, my lord.
It is annexed.
It is annexed in my reply. I
You
thought
don't
that
have
let
a
me-
copy.
I have annexed that.
No, otherwise you don't
Yes,
have a
yes.
copy.
Copy.
It will become easier for,
I always feel that copy is much
it's
more.
much easier.
Hasn't it? 590, yes.
It's all right if it is
No,
not.
it's have, yeah. Leave it.
Borba.
I like also copy with Berek This year we belong to a very old school.
Correct.
When we all seniors.
In fact, I still
Second.
prefer the books
I same.
in the
Same here.
chamber because then those markings stays.
Yes, yes.
Next time you
Always-
open
always
that
with
book,
books, yes.
it
Yes,
just
sir.
refreshes. Yes, please.
Well, let's see kindly at 140.
So
You
this
see
is by
that-
the same petitioner, Muslim Ali.
Yes, yes, same, but that's why I'm saying, my lord. Same petitioner.
I remember you had shown me this.
Yes, but
Which
let's
paragraph?
my lord, refresh because it is subject matter.
Yes,
fit.
yes. Which
The
paragraph?
number two, the petitioner who is class 1A contract registered with PWD road in short, participate in a tender process for construction of road of so and so. This is also pertaining to PMGRY. So district comprise of construction road for value of so and so and for maintenance of the road for the next 5 years upon completion of value of so and so, where the completion period of construction was 9 months. In the aforesaid circular, petitioner was issued a letter of acceptance dated 30/7/2007. As per the terms of the contract, 5% of the amount of every running bill is to be deducted as secure deposit, and in the process, an amount of so and so was deducted. Petitioner completed a part of the contract for construction of the road for which he was paid a total amount of 1,86,00,000 so and 1,00,000 so and so as per the bill of payment, and the payments were made in respect of 6 different bills submitted by the petitioner. A dispute has been raised by the respondent in PWD that although petitioner may have completed part of the contract of construction of the road, but the other part of the contract of maintaining the road for the next 5 years has not been undertaken or performed by the petitioner. Exactly same facts. In the circumstances, by the office order dated 8/12/2014 of the executive engineer, the secure deposit money retained from the petitioner from the bill which amount to so and so should forfeited as the petitioner has not undertaken the work of maintenance of the road by further providing said amount would be required for not undertaking the defect correction maintenance work. Respondent in so and so by the communication dated 1/6/2015 has informed the petitioner clause 43.2 of the tender agreement also provide that the engineer has to certify that all defects notified by the engineer to be corrected by the contractor prior to release of the secure deposit, and further that if the routine maintenance work is not carried out by the contractor as per the contract agreement, employer will be at liberty to carry out the routine maintenance work, and the amount required for the purpose will be recovered from the amount of the performance security. In other words, by the communication dated 1/6/2015, respondent rejected the claim of the petitioner for release of the secure deposit, which stood forfeited as per the office order dated so and so. Being aggrieved, writ petition is instituted. Learned Standing Council takes the stand as part of the contract for routine maintenance is also a part and parcel for the same contract work, and as the petitioner having not performed the other part of routine maintenance, therefore the secure deposit is liable to be forfeited, which according has been done in the present case. A reading of the stand of the petitioner is that according to the petitioner, the security money deposited was for the part of the contract work for construction of the road, and it is not related to the routine maintenance part of the work, and therefore the part of the contract work of construction.
They have not gone in appeal against this.
No, I think the appeal goes on. Right. And therefore, the part of the contract work construction road have been satisfactorily completed. Respondent terms of the contract agreement cannot forfeit the secure deposit, although the petitioner may not perform or completed the other part of the work of routine maintenance. On the other hand, it is the stand of the respondent in the PWD that as per clause 43.2 of the tender agreement, the engineer has to satisfy all the defect notified by the engineer has to be corrected by the contractor prior to release of secure deposit. Now, I am pausing for a moment of 10. That is a subject matter. Because the contract agreement of 43.2 specifically, my lord notifies, says that if the security you have taken that amount, you have to release that amount. Or suppose, my lord, there is a defect. They have to notify to me that this is a defect. They have not notified. Completion certificate is given. Now 11, in the instant case, we have noticed that there is no such stand of the respondent. The original work performed by petitioner in construction road was defective, nor that any such defect has been pointed out which the contractor is required to rectify and has not done so as to enable the respondent to forfeit the secure deposit. The stand that has been taken by respondent in the PWD is that petitioner has not performed the other part of the contract work, that is routine maintenance of the work, which was otherwise satisfactorily completed. Non-performing of the other part of the contract work for routine maintenance would be in violation of the terms of the contract by the petitioner contractor. And for such violation, petition can be subjected to the procedure under any relevant provision of the law that may be available, including any such penal provision that also may be available for not performing a particular requirement of a contract work. But at the same time, security money that has been forfeited is directly related to the part of the contract work of the construction of road, which work even according to respondent otherwise has been satisfactorily performed. And further, no defect therefore could be pointed out by respondents to entitle them to deduct the security deposit.
This is the same facts in your case, because
Same.
even in your
Exactly
case,
same.
because they have not notified any defect, therefore it
Correct.
is assumed that you have satisfactorily
Right.
completed the work of construction.
Yes, correct.
Routine maintenance is different. but
Original
as far
work.
as the original work,
Original work,
there
no
is
defect.
no,
Yes.
isn't it, Mr. Gogoi? Because
No, but-
nothing on
Yes.
record to show that you are not satisfied
There's
with the
some defect
construction.
in the construction work. There's no
Correct.
such.
That is, so
Right.
therefore, that part, paragraph 12 squarely covers
Yes.
in your case also the
Yes.
facts.
Yes,
The
factually
context.
it is,
I'm talking
yes.
about the context.
My lord.
No, correct, my lord. Now kindly see 13. From such point of view, we are unable to accept the stand of respondent that because other part of the contract work for performing the routine maintenance work has not been performed by the petitioner. Therefore, the security deposit which pertains to the part of the work of the concerned road,
And this
also
contract
liable.
is also same,
Same.
similar terms and conditions.
PMGRY, routine maintenance.
Why should this code not
My lord, I
Yes.
will please.
follow this coordinate bench? You have to satisfy me that, because
Well-
I don't see a reason for taking a different view.
No, my lord will carry the operative portion. Accordingly, we direct the respondent that PWD to pay the security deposit pertaining to the part of the contract work related to the construction of the work. But however, as the petitioner has not performed the other part of the contract work in undertaking routine maintenance, liberty remains with the respondent take any action under the law as may be available, including any other penal provision for not performing the other part of the work. But in doing so, the appropriate procedure of law will be followed. I think with great respect, my lord, I think the judgment doesn't have any flaw in it because totally it has been discussed.
Yes, yes.
Second judgment.
And second judgment also is the
Of the
same.
same,
Second judgment.
same
also-
author.
Yes.
Yes.
Same, my lord. Second judgment also pertains to same. And if your lordship looks into, very interesting, your lordship looks into the affidavit which has been filed, the opposition by the chief engineer,
Against this also no appeal?
no appeal. Now, my lord will kindly see the affidavit in opposition filed by the chief engineer
Yes.
at page 131.
131.
One. I think annexure E.
Yes.
See kindly, my lord, 1, 2 is the present the works, 29 and 33, the present case in hand.
Which one is the present case in hand? Number,
1 and 2, serial number 1 and 2.
serial number 1 and 2.
This is AS 2029 package number and AS 20 and
Defect
33.
correction work executed by another contractor.
Yes. This is by Muslim Ali, same contractor. The same contractor.
Acha, acha.
29, if your lordship looks into the writ
So the
petition,
earlier was Abidur Rahman.
which one, my lord?
By another contract, no, I am,
This is, no, my lord will is looking to 131.
yes, serial number 1 and 2 you are saying is the present contract.
No, that is,
Correction.
no, what they have done, my lord, your lordship is reading the remarks.
Yes.
Defect correction was executed by another contractor, so and so paid is a utilizing forfeited as the money. They have mentioned that. So this is,
Sorry, I'm not
I'm
following.
telling you, one is a routine maintenance, one is the security money or the original work, and one is the maintenance work. Now, maintenance work, as he could not carry, it is done by another contractor,
Acha, so this is the maintenance work.
maintenance work. They have given to Ahedur Rahman,
Yes.
the maintenance work.
And this money
con-
is by utilizing the forfeited SD money.
Yes. Now, my lord will kindly see number 2 also same, defect correction work executed by another so and so,
Hmm.
paid so and so. Defect liability cannot be in respect of the original work. Routine maintenance is a separate work altogether. That's the period. And for that, my lord, additional performance is given to us. You have to pay a separate head for routine maintenance. It's nothing to do with the security. Now, kindly see serial number 3. That's the reason what I am showing, my lord, serial number 3 at page 131. See 131,
Yes,
AS 2049.
serial number 3, yes.
So and so, defect correction work. This is a subject matter where lordship, I was reading the judgment, that judgment. WPC 5933 of
5933.
2033 of 2015. That's what your lordship I have read. That's the subject matter. Here also they have done the same thing, but that was interfered by the court. That is interfered by the court. No appeal has been filed against that order as on date, my lord. So what is the
Which is the
argument?
where can you, from the record, where do you find that the additional performance has been paid? You have just submitted that an additional performance has been paid
Yes.
in respect to the routine maintenance work.
Now my lord will kindly look into it. 43, 37 kindly be looking, 37 of the writ petition. Now your lordship was asking, what is the contract about?
No, 37, I think, is part of the contract.
Yes, that's what I am showing in secure deposit. Kindly see, my lord.
Yes.
See the secure 43.1. Heading is secure deposit. The employer shall retain secure deposit of 5% of the amount from each payment due to contractor until completion of the whole of construction work. No secure deposit retention shall be retained
Yes,
from
they have
payment.
used two words. This we have seen on
Your lordship has looked into it.
Yes,
No
43.1 is security deposit and no security retention shall be retained from the payments of routine maintenance of work. It is
the-
clearly given.
Yes.
Then they use the word in 43.3 additional performance security.
Yes, well, what happens additional performance security is suppose your bids is a very unbalanced bid. Suppose some.
And in 43.4, it is more clear.
Yes,
And additional performance security for maintenance,
Yes.
for routine maintenance.
yes.
Now, that is why my question to you is, have you paid this additional performance security? From which document can it be seen? Is
No.
it there on the record?
Oh, no, it
That-
has not been
that
paid
is-
to us. That's no additional performance is not being paid.
No, additional performance security will be paid by you, will be deposited
My
by
lord,
you.
no, kindly see at page 152, they have admitted that no additional performance security was paid to us. Kindly see, is taken from the, no, at page 153.
No, Mr. Das, I am just trying to understand. There is a small doubt in my mind.
Yes,
Is this additional performance security, because it's the word is security, right?
yes.
So I think you have to pay prior to the
Contract.
work commences.
Yes.
And this they will pay it to you after the work is over.
Right, completely correct.
Now, in this case, that must have been paid,
That's what, they have paid the performance.
not
security.
them, not them.
No, I know.
The
The
contractor.
contractor has paid only the performance security, my lord.
So
If
they
your
did not
lordship,
pay the
no,
additional performance
that
security.
because that cannot arise. That cannot arise, my lord, because if your lordship looks into it,
All right, anyway, then it's all right.
1 second.
Let's not make it more complicated
Yes.
then.
Yes,
My lord, may I say, my lord,
No, no.
additional performance security is required to be paid. Say, my lord, in a particular tender, our benchmark is, my lord, -10. Say, my lord, 1 lakh is the, my lord, bid value. Somebody quotes a rate of 80,000, my lord. In that case, for 10 lakhs, my lord, that has gone below, my lord, 10%. You will have to pay additional performance guarantee. Because according to us, my lord, at
But
80
you see, when we read this, Mr. Das, let's read this entire 43 clause once. You
because
can read it
I
slow.
don't know, that's my instruction. My instructing counsel at one point of time, he is saying now to me, that's why I'm just giving a reply. He said that there at one point of time, your lordship has asked the other side, my learned friend, that whether that additional performance security was taken from the contractor or not.
Correct.
Now, specific averment they have made.
Yes, not
In the
required in
reply-
this contract.
No,
Not
that's
Because
why.
not required in this contract.
In this specific case, no additional performance is taken. from
This is in
contractor.
the written argument.
Yes.
No, my lord, in
Because
the
your
affidavit we have
lordship-
stated.
Your lordship in their affidavit, because there was an order passed by the honorable court to file an additional affidavit to the effect by the order dated 22/11/2024 and 2012/2024. That was the specific. And they have said,
Where is that additional affidavit?
additional affidavit, no, my lord will kindly.
Page 150.
151?
Yes,
One,
And where have you said this?
this,
My lord, the page 153.
153.
No, where is that statement about
B, my lord, para B.
Para B.
Parabi? In this specific case, no additional performance
not
security is
That's
taken
the
from
whole
the
case, my
contract.
lord. If no additional performance security is, so it is,
Okay,
my
Mr.
lord,
Das,
what I'm saying,
let us go back to page 37.
36,
Please read 43 slowly now.
yeah, 43.
Because since 43 is what this court has to ultimately interpret,
No, 43 is the main.
correct,
43.4, I was going again and again.
correct. Please
43.4.
read the entire 43 from
40
43.1.
43.1, the
Yes.
employer shall
Slowly.
retain, the employer shall retain secure deposit of 5% of the amount from each payment due to the contractor until completion of the whole of the construction work. So we put a full stop here, pause for a moment. That means every running bill, my lord, 5% they will
Will be
keep as a
will be
security.
retained.
That's number one. Second, no security deposit retention shall be retained from payment for routine maintenance of work. That's
Yes.
also very clear.
Yes,
So that no point of time they can retain this security
yes,
for routine maintenance.
yes.
Now let us read 43.2. On the satisfactory completion of the whole of the construction work, half the total amount retained as secure deposit is repaid to the contractor. 1/4 of the total amount retained as secure deposit repaid to the contractor at end of the second year after completion of the construction work, and the balance of the amount retained as secure deposit is repaid to the contractor at the end of the third year after completion of the construction work, subject to condition that the engineer has certified that all defects notified by engineer to the contractor before the end of period prescribed for repayment has been corrected.
In your case, certificate is there that all, that
That-
there was no question because there was no
question.
defects.
That's right. Somebody said there was no, it was not. So it is admitting by my learned friend
Okay.
also.
Still
Now,
here,
if-
no difficulty to
no difficulty.
understand.
43.3, the additional performance security for unbalanced bid as detailed in clause 51 of the
This is
condition.
also not applicable
No,
because
for-
in this specific case, no additional performance security was taken.
Please look into 43.4, which
Yes.
is most important.
Yes,
The performance security equal to the 5% of the contract price
and
and
additional
additional performance security for routine
as
maintenance
detailed in
as
clause 5.
detailed in clause 51 of the condition of the contract is, we'll go to that, my lord,
Yes,
is
is repaid.
returned to the contractor when the period of 5 years
years.
fixed for routine
This is
maintenance is
different.
over.
This is different.
Different. Now, if the routine maintenance part of the contract is not carried out by the contractor as part this contract, employer will be free to carry out routine maintenance work, and the amount required for this work will be recovered from the amount of performance security available with the employer and or from any amount of the contractor, whatever is due.
Till here, there is no doubt in the mind of the court, subject to what Mr. Gogoi is going to argue, because this is absolutely unambiguous and absolutely clear that security deposit and additional performance security are two different heads. As regards the construction of work is concerned, every time the bill is being paid, the employer shall retain 5%. And after and how the repayment is to be given is also given under 43.2. There is no difficulty. The
Yes.
last installment after the completion, subject to the certificate, will be cleared. There is no difficulty at all. And it is an admitted position that in this case, the contractor has completed the work to the
Yes.
full satisfaction of the employer.
Yes.
This is an admitted position.
Absolutely,
Now,
absolutely.
this takes us to the additional performance security, which they have said in the affidavit that they have not taken it.
Yes.
If they have not taken it, it is for them to suffer the consequences.
And they can very well definitely the learners in a coordinate bench.
Security is not required to be taken.
No, but
You see, Mr. Let's go to 51 once.
51, yes.
I'll come to you, Mr. Gogoi.
Well,
I'm indicating my mind so that you know exactly where to reply.
Not
Only for that purpose.
51, your lordship will find at least 40.
Yes, please.
40.
Yes, please.
Operating and maintenance manual. 51.1.
Yes.
If as bill drawing and or operating and maintenance manuals are required, contractors have supplied them by date stated in the contract data. 51.2. If the contract does not supply a drawing and or manuals by dates stated in the contract data, or they do not receive the engineer approval, engineers have withhold the amounts in the contract data from
What
payment.
is contract
due to
data?
Why, my lord,
What is contract data?
contract data is
Is it
defined.
defined?
It's been defined. Yes, it has been defined.
Yes, page 26. I think I
26,
had
that's
already
what-
asked this question because I
Yes, yes,
find it
your
is all
lordship has
marked.
asked. Contract
Defines the
data
documents and other
defines the
information which
document under,
comprise the contract.
it defines the documents other information comprise the contract.
All right. Yes, anything more, Mr.
No,
Das?
that's all, my lord.
Yes,
because the
Mr.
codeless
Gogoi.
ones- My lord. Hold on a minute. Okay. My lord, with your lordship permission, my lord, just, I am Mr.
Yes,
Parker.
yes, yes, yes.
I just
Please,
took the permission, I came here.
please go ahead.
I am deeply obliged, my lord.
And I would like to point out to para, clause number 32, page 34 of the contract. agreement.
Page number
34,
34.
yes.
Yes.
32 says whether correction of defects noticed during the defect liability period and routine maintenance period for 5 years. 32.1.1 says when the engineer shall give notice to the contractor for any defects before the end of the defect liability period, which begins at completion and ends after 5 years. So whether after the completion of the work, the period starts and it will continue till 5 years. The defect liability period shall be extended for as long as the defects remains to be corrected. 32.1.2 says every time notice of defect or defects is given, the contractor shall correct the notified defect or defects within the duration of the time specified by the engineer's notice. 32.2.1.
Where is this notice?
No, here it is regarding my routine maintenance, not on this part. My lord,
No,
32.
have you given this notice?
No, it's not required. My lord, lordship is in next part, my lord. This is relevant. 32.2.1. The contractor shall do the routine maintenance of the works, including pavement, roadsides, and cross drains, including surface drains to be required standards and in the manner as defined in clause 1.1, and keep the entire road surface and structure in defect-free condition during the entire maintenance period, which begins at completion and ends at after 5 years. So duration of my lord defect liability period and my lord the maintenance work, my lord, it remains same from the date of completion till next 5 years. But these are two separate heads, my lord. 32.2.2 says the routine maintenance standards shall meet the following minimum requirement. 1, potholes on the road surface to be repaired soon after this appear or brought to his notice either during contractor's monthly inspection or by the engineer. 2, road shoulders to be maintained in proper condition to make them free from excessive edge drop off, roughness, so and so. Well, these are the conditions when my lord routine maintenance will have to be carried out.
32, 33.
Yes. 32, yes, my lord. Now, lordship will see 32.2.3 next page. To fulfill the objective laid down in subclause 32.2.1 and 32.2.2, 2.2 is my lord routine maintenance. The contractor shall undertake detailed inspection of the roads at least once in a month. The engineer can reduce his frequency in case of emergency. The contractor shall forward to the engineer the records of inspection and rectification each month. The contractor shall pay particular attention on those road sections which are likely to be damaged or inundated during a rainy season. 32.2.4 says the engineer may, it says may, my lord, lordship may kindly issue notice to the contractor to carry out maintenance of defects. Period under clause 32.1.1 and clause 32.2.2 of these conditions of contract to the satisfaction of the engineer within the time specified in the engineer's notice. The engineer will assess the cost of having the defect corrected, and the contractor will pay this amount on correction of the defect. Now, my lord, there are two words, my lord, I'd like to point out. 32.2.3 says, my lord, in the very first line, to fulfill this objective, so the contractor shall undertake detailed inspection. It is upon the contractor, my lord, you have to do that for the next 5 years.
All right, if he doesn't do, you know what is to be
Yes,
done.
yes, that's
You are
Now,
not
lordship,
remediless, Mr. Gogoi, but your 33.1, which talks about uncorrected defects.
my lord.
If the contractor has not corrected a defect pertaining to the defect liability period under clause 32.1, and clause 32.2.
Yes.
That
to
means
the
even
employer.
for 32.2, a notice is required to be given. And admittedly, no notice has been given for maintenance also, isn't it?
No, here, my lord, for
I'm just
maintenance,
asking facts.
but
It
from
is,
the,
I have seen you have indicated May in 32.24
Yes.
and you laid stress on May.
my lord,
Now, my question to you is, otherwise also, as for the
Well, that
routine
part,
maintenance part is concerned, no notice is given.
but that I cannot say, my lord, because.
Because
this
that is there in your affidavit, there is no whisper.
Nothing, my lord,
There is
no
no
whisper, yes,
whisper.
yes. My lord,
Then
33.1,
now let us proceed.
my lord, 33.1
One
says,
second,
if
let
the
us-
contractor has
Mr.
not
Gogoi,
corrected.
one second. And clause 32.2 of these conditions of contract,
Yes,
to the satisfaction of the engineer within the time specified in the engineer's notice, the engineer will assess the cost of having the defect corrected and the contractor will pay this amount on correction of the defect.
my lord,
Correct?
my lord.
Yes. Next,
Now, my lord, 38.2.
38.2.
My lord,
Yes.
this is not relevant. My lord, 39.4.
Yes.
Payment for the routine maintenance of the work shall be made half yearly for so and so. Maintenance of the work certified by the engineer and based on the monthly bill submitted by the contractor as per
Yes.
clause 38.2.
Yes.
Now, my lord, 43, my lord, I'd like to point out here, my lord, that 33.1 says the employer shall retain security.
Yes.
This clause only prescribes regarding retention, not about, my lord, forfeiture.
Yes. Yes.
If the employer shall retain security deposit of 5% of the amount from each payment due to the contractor until completion of
Because
the,
how security deposit is
to be retained.
because there is no provision for them to pay a security deposit at the beginning.
No.
Correct?
Yes.
So now how will that be accumulated? It can be only accumulated
As per clause
clause
43.1.
43.1.
Now the next
And
line says,
43.1 is very clear. No security deposit retention shall be retained from the payments for routine maintenance of work. As an officer of the,
my lord, here, my
I'm
lord,
sure
my,
you cannot
no, my lord,
argue
my submission will.
against this.
No, I'm
isn't
not
it?
against this, my lord. My submission is that, my lord, so far as the present contract is concerned, pursuant to clause 43.1, we have not retained any amount
That is for you.
for routine maintenance.
You see, no, you cannot even do that
Now, that's why I'm saying we have not done that.
because you cannot do it, Mr. Gogoi.
Yes, we
That
cannot
will
do
go
it as per
against the
yes.
contract.
Now, my lord, 43.3.
Because you see, the issue now comes is whether your action in forfeiting the security deposit on the ground that the contractor has not carried out the routine maintenance
that I'm
to your satisfaction is correct or not correct. That
Now,
is
notice
the
you will
only
see-
issue.
Yes,
And to answer that issue, you have to show it from the
I will
contract
show it, my lord. From
that
the
the contract
two
permits
clauses.
you to forfeit the
two-
security
from two
deposit.
clauses, I will show it, my lord.
Yes, because
What-
you see, retention of security deposit is not for routine maintenance.
My lord,
Clause 43.1 is absolutely clear.
no,
43.1
regarding retention
is
part, it is
correct.
very clear. We
No,
cannot
because
retain
you
for
see,
performance security.
retention is for what purpose? Retention is for the purpose that tomorrow, if you do not do something, you have some security deposit in your hand, which you can hang on to. That is the purpose?
Well-
Yes or no?
My lord, but subsequent clauses, my lord, allows us, I will
Yes.
point out that.
Yes, yes.
43.3 says, my lord, regarding the additional performance security. to be
Yes,
clear
yes,
from
yes,
this,
please.
The additional performance security for unbalanced bid, my lord, if it is too low, my lord,
Yes,
then, my lord, additional performance security is sought for. In the
yes.
present case, my lord, it was not an unbalanced bid, so additional performance security was not sought for. It was not
Okay.
required.
Okay.
43.4 says,
Yeah.
the performance security equal to 5% of the contract price and additional performance security for routine maintenance as detailed in clause 51 of the condition of contract is repaid to the contractor when the period of 5 years fixed for routine maintenance is over and the engineer has certified that the contractor has satisfactorily carried out the routine maintenance of the work. If the routine maintenance part of the contract is not carried out, this is relevant, out by the contractor, as per his contract, the employer will be free to carry out the routine maintenance work, and the amount required for this work shall be recovered from the amount of performance security available with the employer and or from any amount of the contractor whichever is due. Be it performance, security deposit or any manner of unpaid bill, whichever is due.
You
And
want to
lo-
interpret this as
Yes, my lordship will now, I will like to point out, my lord, one more clause.
Hmm.
46 at page 39.
Yes, securities.
Securities, the performance security equal to, my lord, relevant will be that italic part, my lord, down below.
Mm.
In the second paragraph of that, my lord, 46.1.
Yes.
If the performance security in the form of bank guarantee is in the form of bank guarantee, the period of validity of bank guarantee could be 1 year initially. However, the bidder or contractor would get his bank guarantee extended in such a way that an amount equal to 5% of the contract price is always available with the employer until 45 days after the lapse of the defect liability period. If the bidder or contractor fails to maintain above performance security, the employer will recover the same from any dues payable to the contractor. Now, my lord, in the additional affidavit that we have filed, we have made a statement that, my lord, the bank guarantee got lapsed. It was not maintained. That's why this particular clause empowers us that the employer will recover the same from any dues payable to the contractor. This is my argument now, my lord. Lordship will kindly have a look at that order of the
Security deposit are due.
my lord.
Is security deposit an
Any dues,
amount
my lord.
due?
Yes, it will be, because we'll have to refund it if there is no, my lord, defect during the defect liability period. So far as the security is concerned, performance guarantees regarding maintenance part. After all, my lord, these are public works. If the contractor does not perform it, ultimately the public money will go waste, my lord. We'll have to
No,
mend the work,
you are absolutely right. But you see, the catch is here.
my lord.
It is not a case where the contractor has not performed the contract, the construction work. The construction work has been performed. He has performed it. And it is, and you are fully satisfied also.
Lordship.
There is no doubt in that. Now, would it be right in that situation to retain the security deposit, which was for the construction otherwise, as appears from the first clause, because that bill, from the bill that you are retaining it for the purpose of the work. There was no, the clause prohibited retention on account of routine maintenance.
Yes, sir.
Now to, you see, now to turn around and say, no, because the routine maintenance was not done, therefore, you can forfeit that security deposit. Appears to be slightly
No, my lord,
not,
it was the duty of the petitioner to complete it, my lord, as per the contract, my lord.
see, as far the routine maintenance is concerned, it is not that you are left with no remedy. You have all the remedies.
No, my lord.
You know what is to be done. There are, you need to take actions. There is no difficulty. But as far as the retention, the forfeiture of the security deposit, I don't see any.
No, not, my lord. Lordship, there are two things, my lord. Forfeiture is one thing, my lord. Two, my lord. To retain only that part of the amount that has been, my lord, spent on, my lord, maintaining the road is a different thing, my lord. Here we have not said that, my lord.
Correct, but you see, retention.
Forfeiture is the word they have used, but
You see,
not the proper word.
retention otherwise is for the purpose of
Defect liability period. my lord.
correct, purpose of securing, isn't it?
Yes.
That if you don't do it, then there is a security in your hand.
No, not non-performance, my lord. It's for, my lord, say in the defect liability period,
Correct. See,
some defect is pointed out
Either
in the construction
in the
work.
construction work. That is what I'm saying.
Yes.
So like if you have not done it with properly and tomorrow at inspection, it comes to your
No, I
light
am saying
that
it-
some lapses are there. You can always get it corrected. If he does not correct it, then you will forfeit that particular
my
amount.
lord, why I'm saying forfeiture is something, my lord, where he will forfeit the entire security deposit. Here is a case, though the term forfeiture has been used, my lord, not properly used, my lord, in fact, I would say. But, my lord, out of the security deposit that was due with us to the petitioner, after deducting 5 lakhs, the remaining amount has been given to him in one tender, my lord, that we have stated already.
No, in this case, it's two tenders.
No, 2 tenders.
In the subject case,
in the other tender, my lord.
there is another case,
There are two works, my lord.
but in one case.
In this particular case, there are 2 works.
Okay.
Yes.
So in respect of one of the work, the balance security has been paid.
Already paid. After deduction, my lord. So forfeiture
It's
is something.
there
my lord,
in
the
your
entire amount
affidavit.
is- Yes, it is there,
Where?
my lord.
50% paid, Lord.
Hmm?
50% paid.
Because the other
50% of
part,
the expense.
In other work, nothing
you
else.
see, Mr. Gogoi is saying that the balance which was lying, they have paid. after forfeiting
Yes.
whatever they have spent for
119.
routine maintenance.
Page
This is
119.
their stand.
Then yes,
Mr. Sharma, this is their stand.
yes, sir. Also, they have even in this particular lordship packages, they have not communicated that the this amount is forfeited. But in the judgment which was read by my senior lordship, in that case, they communicated that this amount is forfeited. But in these two packages, lordship,
There is
even
no
they have
communication.
not
There is
communicated.
also no notice that you have not carried the routine maintenance
Right.
or that this is the
Any, I have-
lapses or corrected.
Correct, in-
Absolutely nothing.
Nothing.
Straight away, they have
Lordship.
deducted it from the
Only after
security
filing this
deposit in one case and returned the balance. And in the other case, nothing has been paid back.
But balance is there, we will pay, madam. Page
Where-
119.
where
Page
page?
119, madam.
119
Madam.
in your
Affidavit is a part of our first affidavit.
first
Affidavit of opposition. Package number, madam, 29. AS 2029. Lordship will see the chart. A says that total SD amount retained from the bill is 10 lakhs 37,331. Lordship will see the word used is retained from the bill. So it is as per clause 43.1. So B says SD amount 50% released on 12/8/2011, rupees 518,830. Remaining so and so forfeited for defect correction on 12/9/2024. 14. 518,831. Now expenditure already made for defect correction is
This is in relation to which work?
29, my lord. AS 2029.
Where do I get that?
My lord, Lordship will find it in the relevant para of the requisition. This is our response.
No, because this is only in respect of one work.
Uh,
This chart is in respect of only one work.
No, yes. Now, Lordship will see in the next page, my lord, the balance amount still is due after deduction.
No, that I have seen. That's
Yes.
why I want to be
Yes.
clarified.
For the next work, my lord, Lordship will find that, my lord, 1 to 1, page 1 to 1.
Okay, okay. Now, which is the
First one is the, my lord, package number 29,
package number
AS 2029.
AS
2029.
2029? This
Second is, my lord,
is
AS.
can we refer it as the first package?
Yes, first package, sir.
And the second one
AS
is a,
2033.
AS
2033.
AS 20.
33.
We can refer it as package
Package
number.
number 2, 1 to 1. Page number 1 to 1.
Here you have paid.
SD forfeited for defect correction is 6 lakhs out of 13 lakhs. There are twice, my lord, it has been deducted for 2 corrections, my lord. One is 6 lakhs.
Here also there is available balance.
It's only 1,61,000.
Where have you paid?
No, it's due, my lord, we will pay it, my lord, because
So
of
in both the packages, you have not paid anything.
no, in the first package, 50% was already released. Out of the 50%, what was retained, Lordship will see. B,
Sorry, I think I missed that.
119 says.
Oh,
B.
remaining 50 SD amount 50% released on so and so.
So,
Okay, okay.
out of the remaining, my lord,
Okay.
expenditure is in the next.
All right. I stand corrected.
Now, Lordship will see, my lord, the judgment that has been relied upon by the other side of this honorable court. Para 11, Lordship will see. 149. Oh, yes, para 11. In the instant case,
Yes.
we have noticed that there is no such stand of the respondents that the original work performed by the petitioner in construction of the road was defective, or that any such defect has been pointed out which the contractor is required to rectify and has not done so as to enable the respondent to forfeit the secured deposit. The said stand has been taken by the respondent in the PWRD is that the petitioner did not perform the other part of the
Same.
contract.
It is same.
No, this stand was not there in that case, but this is a
Which
specific
stand?
in the
Which stand was not there?
that, my lord, last part, the stand that has been taken by the respondent in the PWRD is that the petitioner had not performed the other part of the contract work, that is a routine maintenance of the work, which was otherwise satisfactorily completed. Now, Lordship will see in para
What is
para 6. No, what will be para
Mr. Gogoi, even in this
It's covered.
case,
Otherwise, my lord, the issue is covered.
correct, no,
Para six.
because you see, even in this case, admittedly, there is no defect in the construction work. Admittedly,
Only routine maintenance.
correct,
Fine.
and according to you, the routine maintenance
Yes.
of the work is not that. That is
But
your case.
now para six, my lord. What we will see. Only clause 43.2 has been referred to. Here I have placed, my lord, I am relying upon, my lord, the clause.
Yes, I will look into that.
Yes. So that part, my lord, more particularly, my lord, 43.4, that I'm relying upon,
I'm
and
not-
46.
So simply say this is covered. You have made arguments and
No,
I
this
have
is, this is my argument, my lord.
I
that
have a duty
Since,
to.
my lord, yes, might be, my lord, in that contract, my lord, 43.
But you see, to be frank, I'm still not with you as far as this is concerned. I'm going to finish this. Bhagavana Pisadahi. Because according to me, the contract itself distinguishes these heads: security deposit, performance security, additional performance security. Everything is defined. And that security deposit, as you have shown, that first 43 clause, that refers to, hear me out.
My lord, my lord.
That refers to retention in respect of the construction work. And
Defect in the construction.
and it specifically says retention is not for routine maintenance.
My lord.
Then the 33 which you have shown, that talks about that if you don't correct it, the contractor has to pay.
Yes.
That is also said. Now that doesn't say about forfeiture or adjusting it. That clause doesn't say. Another clause says from any other dues.
Yes.
Now that is where the catch is, where the court has to now interpret
Whether
that.
dues will cover.
Correct,
the
correct.
security
Now to do that, I have to keep in mind what were the intention of the makers of the agreement.
My lord.
The employer, what is the intention, what is in their mind, right?
Lord.
Now, if we go through all these clauses,
My lord.
it is very clear that security deposit is for not for any defect, because it talks about the defect liability.
Yes.
That is a separate thing.
Lordship.
So if I am of that opinion, then comes the rest of the thing which this judgment is has already taken care of.
My lord.
Whether that any dues would give you the handle to go to the security deposit.
Mm.
That is the only crux.
My lord, yes.
That clause
But
is
my argument will be, my lord, that dues will cover, my lord.
yes, that is
Anything
what
that
you
is
have
due to the
argued.
petitioner.
Now but that argument
And
has
but-
to
and another, my
has
lord,
to be read
how, my
with,
lord?
you see, it has to be read with the other clauses of the
Yes. In
contract.
concurrence
It
with the
cannot
other
be
clauses.
read in isolation. Which was that clause? It is at page,
43.4.
no, page,
35.
yes, page 38.
38. Yes. Internal
Right.
page 74. Of the
38,
contract. Yes, sir.
38, isn't
Yes.
it? And or from any amounts of the contractor, whatever is due. Now, another thing, the last part of the security deposit is repaid to the contractor at the end of the third year after completion.
Yes, sir.
Correct?
My lord.
Now here, Mr. Sharma, in the facts of this present case, when was this routine, this money not given to you? The third year, how many years have gone by after the completion of work? I'm not talking about till date.
In their affidavit, they have admitted lordship one work is completed in the year 2010 and other is in 2013.
Because you see, the routine maintenance is for 5 years,
My lord.
Lordship.
isn't it? Am I correct?
Lordship.
Somewhere I remembered. It is for 5 years.
5 years.
Which was that clause which
Lord,
was
you
5
will-
years?
Yes. 32.
Lordship,
32.1.
Yes, and 5 year.
And 32.2.1 speaks about, my lord, the routine maintenance. It's again 5 years.
32,
time.
32 point, yes, which
2.1.
begins at completion and ends after 5 years.
Same.
And within 3 years, you are required to return the entire security deposit.
No, my lord, there.
Yes,
there-
43.2.
No, there are two things, my lord.
I will come to the second thing, but 43.2, how will you read otherwise? Read 43.2. On the satisfactory completion of the whole of the construction work, half the total amount retained as security deposit is repaid to the contractor.
My-
1/4 of the total amount retained as security deposit is repaid to the contractor at the end of the second year after completion of the construction work, and balance of the amount retained as security deposit is repaid to the contractor at the end of the third year after completion of the construction work, subject to condition that the engineer has certified that all defects notified by the engineer to the contractor before the end of period prescribing for repayment have been corrected.
Yes, that probably is not there, my lord.
So 3 years, 3 years is the
3 years.
time limit. If they don't do anything, of course, you have that right.
Then
But if it is done, then there is no way you could have kept the security deposit. You should have given it at the end of the third year. Sorry. Yes, please take down. Councillors, you may take your seat.
My lord.
All right, Mr. D. Das, Learned Senior Counsel, assisted by Mr. P. Sharma, Learned Counsel for the petitioner, one petitioner, and Mr. B. Gogoi, Learned Standing Counsel, Mr. Gogoi,
Yes, ma'am.
Standing
Standing council, PWD road.
Learned Standing Counsel, PWD,
Road,
roads
my lord.
for all respondents,
All respond.
for all the respondents.
Yes.
Stop. By way of this petition under Article 2 to 6 of the Constitution of India, the petitioner is assailing the illegal, arbitrary, and malified actions of the respondent authorities in not releasing security deposit amounts to the petitioner in respect of road construction works under package number AS-20-29 within bracket ADB and AS-20-33 within bracket ADB for Nalbari district in Assam. Full stop. The brief facts of the case is that the petitioner is a class 1A contractor under the PWD Assam. The respondent number 3 had allotted 2 road construction work to the petitioner from number 1, HMD Road to Bartal number 3, Bamunbari to Mulak. You will get all this in this highlight. I'm just putting a flag, orange flag. This is the written arguments by the petitioner. Roman 1. Okay. And towards the end, where it is written page 19 to the writ petitioner, don't write that. Instead of that, in bracket, you say hereinafter referred to as package number Roman 1. So we'll refer it as package 1.
1 and 2, my lord.
Yes. And then Roman 2, also you quote at the bracket where it is at page so and so to the writ petitioner, hereinafter referred to as the package number Roman 2. Okay?
My lord, one thing remained to be pointed out. My lord, just one thing.
Yes, Mr. Gogoi?
Yes, my lord, 43.2 says, my lord, it says, my lord, the remaining amount will within 3 years will be paid, my lord, provided subject
Yes.
to the condition that the engineer has
Yes,
certified that
yes,
all defects
that's it.
notified by the. Now, my lord, there is a certificate enclosed to the petition which says that, my lord, that certificate has been issued.
Yes.
But, my lord, in the affidavit, we have stated
Yes.
on verification, when, my lord, we found that, my lord, that was wrongly issued, it has been cancelled.
Maybe.
No, without the certificate as part of condition.
You see, that you have cancelled later on. But initially you have, because there is, Mr. Gogoi, let us be very clear.
My lord.
As far the construction work is concerned, there is no defect. This is an admitted position. Now let's keep it in that. The question is now whether your actions, yes.
For the routine maintenance.
Yes,
can it be
yes,
done?
yes. That
That,
is it.
yes.
So
The
let's not.
factual part, I'm
Correct.
clarifying the
Correct.
factual
No,
part.
no, that's all right. So I am not going into all
No.
that. You see, the clause is very clear. How you have done it is different.
Lots of.
And you
Only thing,
listen,
madam, that-
you hear me when I'm dictating, Mr. Sharma also. If there is any correction or editing required, take a note after the judge, after the dictation is over, you please feel free to point it out.
Lots of.
Yes. It is the specific case of the petitioner that the respondent authorities, while preparing and passing capital RA bills to the petitioner in both the works in question, had deducted security deposit amount stop. Situated thus representations have been filed before the respondent number 4 in respect of both the packages, which was replied by the respondent number 2 by his letters dated 2010-2022. However, no defect liability certificates were enclosed in the said letter, and since no fruitful results, and since the security deposit was not released, comma, the present writ petition has been filed. Stop. Mr. D. Das, learned senior counsel, submits that the respondents have arbitrarily and illegally not released the security deposit amounts of the above 2 packages, despite the petitioner has completed the work of construction of the subject road to the full satisfaction of the respondent authorities. He further submits that the ground of forfeiture being non-performance of the routine maintenance work, even assuming to be correct, the same does not entail the respondent authorities under the terms of the contract to forfeit the security deposit amount, which was retained by the respondent authorities from the bills of the petitioner in connection with the road construction work, so as to ensure that in the event there is any defect in the construction work, the same can be made good if the petitioner does not correct from the retained security deposit amount. He accordingly submits that the forfeiture of the security deposit being forfeiture of the security deposit is absolutely unsustainable in law and hence warrants interference from this court. He further submits that in similarly situated work contract issued by the respondent, wherein also the respondent had not released the security deposit amount on the ground of non-performing routine maintenance work, the petitioners had earlier had filed writ petition before this court, being WPC 5933 of 2015 and WPC 6154 of 2015 in respect of those works, wherein this court by judgment and order dated 6/9/2022 and 6/9/2022 was pleased to allow the writ petitions by holding that the stand of the respondents in withholding the security deposit for non-performance of the routine maintenance work from the security deposit which pertains to the part of the work of construction of road is unacceptable. I have heard the learned counsels appearing for the contending parties. Oh, sorry. Mr. Gogoi, 1 second. Sorry, Mr. Gogoi. Per contract, Mr. B. Gogoi, Learned Standing Counsel, PWD, submits that under the provisions of the contract, especially by drawing attention to clause 39.4. No, not 39.4, sorry. Where is that clause gone? Yes, 43, no.
43.2.
That any amount?
Page 37.
Huh?
Page 30. 43.
So, my lord, two arguments, my lord. 43.1 says.
I'll address all your arguments.
43,
That any amount due, where is that?
43.4 and 46.
No, not that.
Yes, 43.4, my lord, in next page, my lord, the second para. If the routine maintenance, so and so.
Oh, yes. By drawing attention of this court to clause 43.4, wherein it is agreed that if the routine maintenance part of the contract is not carried out by the contractor as per the contract, the employer is free to carry out the routine maintenance work, and the amount required for this work will be recovered from the amount of performance security available with the employer and or from any amounts of the contractor, whatever is due. He accordingly submits that since the security deposit amount was lying in the hands of, it was lying with the respondent, therefore, the same is utilized for carrying out the routine maintenance work which was not performed by the petitioner. Stop. Correct?
My lord, one more thing, my lord.
Yes.
46 says, my lord, it can be recovered from the performance security.
He further submits that as per
46.
as per clause 46 of the contract, it is clearly agreed that non-performance of routine maintenance can be recovered
Second para.
from the performance security. Stop.
No, however, if he fails to maintain the performance security, it can be recovered from any dues payable to the contractor. Last line of my lord 46. Last line of 46. If the bidder contractor fails to maintain the above performance security.
How is it relevant, Mr. Gugui, about
In the my lord present case, we have taken a stand affidavit that
that he has
performance
not
sec-
maintained?
It's not maintained, it got left.
He further, OP just delete that, and he further submits that as per clause 46 of the contract, if performance security is not maintained, the respondent is entitled to recover the same from any dues payable to the contractor.
Right.
He further submits that in the case in hand, the petitioner has not maintained the performance security.
Lots.
And accordingly, the action of the respondents in forfeiting the security amount is valid and lawful. Stop. Correct?
Deduction from the security deposit. We have not
Deduction,
forfeited it, yes.
and
Because
deduction-
part payment we are going to make.
Deductions stroke forfeiture of the security deposit in this regard is valid and lawful.
And my lord 43.1 speaks about retaining. Here, it
46
nowhere
point?
speaks 43.1.
Yes, that I will indicate in my judgment. Yes.
Well, points, my lord, are there already in my written argument, same points.
Okay.
Short, this type given. my lord.
Okay, I will edit it if required.
Lots of.
I have heard the learned counsel appearing for the contending parties and have perused the materials available on record. It appears that the petitioner was allotted with two work dated 29/6/2001 in respect of package number 1 and 13/7/2007 in respect of package number 2, which the petitioner had satisfactorily completed. Stop. However, despite satisfactory completion of the work, the security deposit amount, which was lying with the petitioner, lying with the respondent in relation to the above two packages, was not released on the ground that the petitioner has not carried out the routine maintenance work. The issue which falls for determination in the case is whether the security deposit amount can be utilized for non-performance of routine maintenance work under the terms and condition of the contract. Correct? Stop. Apt to refer to the relevant clauses of the contract before adverting to the merit of the issue. Clause 1 clause 1.1 of the definition clause of the general conditions of contract defines the contract data as the documents and other information which comprises the contract. The a defect is defined as any part of the work not completed in accordance with the contract. The defect liability period is defined as 5 years calculated from the completion date. Routine maintenance is defined as the maintenance of roads for 5 years as specified in the contract data. Clause 2.1 provides that in interpreting these conditions of contract, singular also means plural, male also means female or neuter, and the other way around. And headings have no significance, and words have their normal meaning under the language of the contract unless specifically defined. Stop. Clause 32 reads as hereunder. A to A, page 34. The entire clause, Clause 33 reads as hereunder. Reading of clause 32 and 33, apparent that the work is essentially in two parts. One, the construction of the road, and second, the routine maintenance of the roads. It further appears that in the event there is any defect, the contractor shall notify the defect within the duration of time specified in the notice for correction. It further appears that in respect of the routine maintenance of road, the contractor has to do the routine, has to perform the maintenance for a period of 5 years from the date of completion of the work. It further appears that in the event the contractor fails to carry out maintenance or perform the fails to carry out maintenance or upon detailed inspection, defect is noted, comma, notice for correction such defects shall be given to the contractor, and in the event the contractor fails to correct such defects, the engineer will assess the cost of having the defects corrected, and the contractor is liable to pay this amount on correction of the defect. Clause 38.2 reads as under. No, I think that you said you are not relying. No, clause, then you go to clause 39. Clause 39 reads as hereunder, page 36. Reading of clause 39.4, it is apparent that payment for the routine maintenance of the roads will be made half yearly for the satisfactory maintenance of the work as certified by the engineer and based on the monthly bill submitted by the contractor as per clause 38.2. Stop. Before you also say clause 38.2 on top. Clause 38.2 reads as hereunder. After that, 39. Clause 43, which provides for security deposit, is which reads here as hereunder. Page 37. Reading of clause 43, it is apparent that as regards the construction of work is concerned, the employer shall retain 5% from each bill amount due to the contractor as security deposit until completion of the whole work. Completion of whole of the construction work. Stop. It further appears that it is clearly agreed between the parties that no security deposit stroke retention shall be retained from the payments for routine maintenance of works. It further appears that clause 43.2 provides the manner in which the security deposit shall be returned back to the contractor within a period of 3 years after completion of the construction work. Subject, of course, to any defects if subject, of course, to correction of the defects, if any. Stop. There is no ambiguity as far, there is no, it is absolutely clear that out of the total security deposit retained by the employer, half the total amount retained as security deposit upon satisfactory completion of the whole of the construction work, half the total amount retained as security deposit is to be repaid to the contractor. Thereafter, 1/4 of the total amount retained as security deposit is repaid to the contractor at the end of second year after completion of the construction work, and the balance of the amount retained as security deposit is to be repaid to the contractor at the end of the third year after completion of the construction work. Subject, of course, to condition that the engineer has certified that all defects notified by the engineer to the contractor before the end of period prescribed for repayment have been corrected. It further appears that as far as routine maintenance is concerned, clause 43.4 provides that the performance security equal to the 5% of the contract price and additional performance security for routine maintenance as detailed in clause 51 is repaid to the contractor when the period of 5 years fixed for routine maintenance is over and the engineer has certified that the contractor has satisfactorily carried out the routine maintenance of the work. It further provides that if the routine maintenance part of the contract is not carried out by the contractor, the employer shall carry out the routine maintenance work and the amount required for this work will be recovered from the amount of performance security available with the employer and or from any amounts of the contractor, whatever is due. It is thus it is crystal clear that firstly, it is the security deposit which is retained from the bills of the contractor in connection with the construction of the work. And the same is repayable within a period of 3 years after the satisfactory completion of the work. It further appears that apart from the aforesaid security deposit, a performance security and additional performance security, if required as the case may be, is also taken from the contractor, which is repayable to the contractor at the end of 5 years fixed for routine maintenance is over. It further appears that in the event the routine maintenance work is not carried out by the contractor, the employer is entitled to recover the amount required for carrying out the routine maintenance from the said performance security available, and also from any amounts of the contractor, whatever is due. The contention of Mr. Gogoi that any amount due would mean the security deposit if the same is payable, is the same is lying with the respondent contractor, employer. Correct?
Well,
Stop. Is not acceptable to this, is not acceptable in as much as the security deposit amount is in relation to the construction of work, and the same is payable within a period of 3 years from the completion of work. In fact, it is clearly stated in the contract that no security deposit retention shall be retained from the payments for routine maintenance of work. That apart, the routine maintenance work being for a period of 5 years, for a period of 5 years, and the contract providing utilization of the performance security in the event such work is not maintained by the contractor, the any amount due cannot be interpreted to such an extent which will nullify the entire object of which will nullify the first part of clause 43. Clause 46 is also 46 is also reproduced hereunder, which provides securities. Clause 51 reads as hereunder. We put all this also, huh? All right, I'll come back in 5 minutes. Any amount from any amount of contractor, whatever is due, would mean that in the case if the performance security is not taken by the respondent, by the employer from the contractor, in that event, if any bills of the contractor is pending due, the employer is entitled to recover the amount required for carrying out the routine maintenance work which was not performed by the contractor. This, however, not this, however, in the event the security deposit is still available with the contractor, the same cannot mean to be due for payment to the contractor, which can be utilized against non-performance of routine maintenance work. S, the security deposit under the terms and conditions of the contract is against construction work alone, and the same is to be repaid within 3 years from the completion of the construction work. The aforesaid terms and conditions are absolutely clear and unambiguous, and words cannot be read into or added by this court so as to suit the convenience of one party to the contract. Turning back to the facts of the present case, it appears from the affidavit in opposition filed by the petitioner, by the respondent, that in connection with the don't say turning back, apt to refer to relevant paragraphs from the affidavit in opposition filed by the respondent number 3 on 30/10/2024, which are reproduced hereunder for ready reference. Okay. Paragraph 5, paragraph 6, quote unquote, you have to do, huh? Paragraph 5, paragraph 6. Seven. Ten. Where have you said that performance security was not
In the
taken?
additional
Okay,
affidavit,
okay, okay. Relevant paragraphs of the additional affidavit filed on behalf of the respondent number 2 on 9/1/2025 is also reproduced hereunder for ready reference. Paragraph
3I,
3,
F, 3F, my lord, page 155,
paragraph 3.
F.
Hmm?
F, my lord. In the next page, end of the para,
Hmm.
further deponent base to submit, my lord, after the chart.
Give that entire paragraph, huh? Paragraph 3. It runs from A to F. Okay. Reading of the aforesaid paragraphs, it is apparent that the respondent has forfeited the security deposit against the non-performance of road maintenance by the petitioner in respect of the subject to work. It further appears that in connection with the first package number 1, 50% of the security deposit was released on 12/8/2011, and remaining 50% was forfeited for defect for defect correction work. It further appears that the respondent has clarified that the defect correction work is in relation to the routine maintenance work, which has deteriorated because the contractor did not carry out the maintenance as required and failed to provide intended service to the road users. In connection with the second in connection with the second work, that I package number 2, Roman 2, it appears that the total that no security deposit amount has been released to the petitioner till date, and an amount of rupees 6,91,700 has been forfeited from the security deposit against defect correction work on 30/5/2015. An amount of 6,91,700 and 482,071. On 30/4/15 and 31/5/15 respectively. It appears that an amount of rupees 1,61,215 is still lying balance from this out of the security deposit, is still lying balance, is still lying with the respondent. It further appears that the construction works were completed on 31/7/2010 and 31/12/2013 in respect of the 2 packages, in respect of package number Roman 1 and package number Roman 2 respectively. It further appears that the 5-year routine maintenance period as well as defect liability period were also over on 31/7/2015 and 31/12/2018 respective. In your writ petition, where did you say that one defect liability certificate was issued?
Paragraph 9, Lordship, page 12.
Page 12. It
Page
further
12.
appears.
Paragraph 9,
It
Lordship.
further appears that though the writ petitioner, paragraph,
Paragraph, Lordship, 9.
though the writ petitioner has, no, it further appears that the no defect liability certificates issued by the respondent number 4, which is enclosed to the writ petition as annexure 8 series,
7 and 8.
7 and 8 series, was later on withdrawn. Correct?
Yes, sir. As per para 10, my lord, 124, page 124.
The admitted position is that, no, what transpires from the above is that admittedly, the petitioner has completed the construction, subject construction work to the full satisfaction and within the time stipulated. It further appears that during the 3 years period after completion of the said work, no defect whatsoever was notified against the aforesaid work by the
Engineer.
concerned concerned engineer. It further appears that there is no plea taken in the affidavit in opposition and the additional affidavit filed on behalf of the respondent that the petitioner has not carried out the construction work properly. On the contrary, Mr. B. Gogoi fairly submits that there is no dispute as regards satisfactory completion of the construction work.
That, my lord, because whatever is there in the affidavit,
Okay,
that was my
okay,
submission.
okay.
After I cannot go beyond that.
All right, delete that. On the contrary, it appears that the dispute is as regards not carrying out the road maintenance work by the petitioner, for which the respondent has forfeited the security deposit amount. Pertinent that no defect at any point of time was notified to the petitioner for correction in relation to road maintenance work. As held above, the security deposit amount cannot be utilized against non-carrying out stroke performance of road maintenance work as per the terms and conditions of the contract. Reference is made to the decision of the coordinate bench of this court in the case of Muslim Ali Supra in WPC, I think we have already said Muslim Ali Supra in WPC 5933 of 2015. Top paragraph 11, paragraph 9, 10, 11, 12, 13, 14 is reproduced hereunder for ready reference. Reference is also made to the decision of the coordinate bench of this court in the case of Muslim Ali Supra in WPC 6154 of 2015. Paragraph 14, the paragraph 13, 14, and 15 of the aforesaid judgment is also reproduced hereunder for ready reference. The aforesaid two judgment of the coordinate bench squarely covers the issue in hand, and I see no reasons to differ from the view taken by the coordinate bench of this court. In view of the above, I am unable to accept the stand of the respondents that as because the other part of the contract work for performing the routine maintenance work has not been performed by the petitioner, therefore the security deposit which pertains to the part of the work of construction of road is liable to be forfeited. Accordingly, I direct the respondents to pay the balance security deposit in relation to package 1 and the entire security deposit in relation to package 2, correct? Pertaining to the package 2 relating to the construction of the road in question with liberty to the respondents to take any action under the law as may be available, including any other penal provisions for not performing the other part of the work, i.e. relating to the routine maintenance. In accordance by following the appropriate procedure of law. Writ petition accordingly stands dismissed. Anything else?
Subject to correction, no, Lordship, subject to correction.
Yes, yes.
One line after recording Lordship clauses, one line has been, Lordship, I heard contractor notified the defect. That should be engineer notified the defect.
Okay, okay.
Subject to correction.
Okay,
Lordship.
okay. If it, I think that is,
After recording.
I
the
think that was not about the facts. It should be engineer notified.
Lordship.
Okay, not contractor, engineer. Just check after the clauses were recorded.
Sir,
Yes,
the liberty has finally been given to us. Sir.
yes, I've given you the liberty. I am not saying that you cannot do anything.
Yes,
Of course you can do anything, but
Not
here,
beyond the contract.
yes, not beyond the contract, because according to me, that security deposit is not for a particular
The news
purpose.
part I tried to interpret with my.
No, but I appreciate your arguments, Mr. Gogoi, but sorry, I'm not being able to accept it.
Lordship. Oblige. Number 2.
May I please your lordship? With concern of other party, I beg to mention item number 2.
You're back to mention. Mentioning hour is over.
Adjournment.
Adjournment.
My senior counsel, he has personal difficulties.
What personal difficulty? It's a
His-
2017 matter.
Sir, this
Who's your senior?
Huh?
Who's your senior?
8OD,
Huh?
8OD. His uncle is passed away. That's why.
Is it?
Yes.
Okay.
A guy on behalf of PK Munian.
Any objection?
No objection.
Miss MS?
M. Parveen.
Sorry?
M. Parveen.
M. Parveen. MSM,
On behalf of 8OD.
MSM Parveen, Learned Counsel, on behalf of Mr. 8OD, Learned Counsel appearing for respondent number 2, seeks accommodation in the matter on the ground that there is a bereavement in the family, in the family of Mr. 8OD, who 8OD. Stop. Prayer is not opposed. Relist after 4 weeks. Did your
Much obligement. Obligement. Item number 3.
Mr. 8OD, Learned Counsel be good.
Yeah, please, your lordship.
Yes.
I filed this matter for quashment, and here the issue involving lordship is whether in a
non-cognizable offense, can police investigate without the permission of the magistrate? This is the issue which is involving this particular case. And the second, can any police officer
Investigate non-cog offense
and file a report without the permission of the magistrate?
without permission.
First, this is the first issue, Lordship. Second issue is whether
Yes.
second issue which involves this case, Lordship, is whether in a final report, two things can be clubbed. Means what has happened, I have filed an FIR, Lordship, before Kokrajhar PS. I am coming to the entire issue, but before that, I'm coming to the main point of this issue involved. I have filed an FIR before Kokrajhar police station, alleging that when I went for there was a direction from this honorable court, I was in anticipatory bail. When I went for execution of my anticipatory bail, I was mishandled. So I lodged an FIR first at my local police station. My local police station said that no, since the entire incident happened in Kokrajhar, it will be sent to the Kokrajhar PS. Matter was transferred, it was sent to Kokrajhar PS. And Kokrajhar PS, what they did, they investigated in my FIR, because there was involvement of some senior police officer. In my FIR, what they did, they filed a closure. Lordship will kindly see.
All right, I'll admit it.
Lordship,
I'll admit it and post it for hearing.
Lordship.
Item 3, huh? Heard Mr.
A Bhattacharya.
A. Bhattacharya, learned counsel for the petitioner. Also heard Mr.
A Chaudhary.
A. Chaudhary, learned counsel appearing for respondent number 2. SH Bora, learned APP for the state respondent. Anybody else?
No.
Are you appearing for someone?
No.
No, Lordship, I am assisting.
Then why are you standing? It appears that the petitioner has made out a arguable case. Admit no formal notice as parties are represented. List for hearing. Yes, when? In the month of?
After due vacation,
In the
Lordship.
month of May 2025 on a date to be fixed by the registry.
Item number 4,
Interim may kindly continue.
Interim, if any, shall continue till the next date of listing.
Lordship.
Lord, I'm appearing for the advocate on behalf of this matter, Your Lordship, Mr. S.K. Jain. He is out of station, Your Lordship. We informed the other councillor also regarding this. Your Lordship.
Mr. Your name?
T. Chetri.
Mr. T. Chetri, learned counsel, submits that Mr. S.K. Jain, who is conducting the, who is appearing for the learned, who's appearing for the petitioner, is out of station and accordingly seeks accommodation. Prayer is not opposed. List after
2 weeks, Your Lordship. Any
Short date may be given.
Yeah, date may be fixed, Your Lordship. Second, much of it.
for order, item number 5.
May I Your Lordship?
delay is still not condoned.
Not condone, Your Lordship. On the last occasion,
219 days.
119 days, Your Lordship.
Who is appearing for the R2? You have objection for delay.
My senior is on another.
Do you have any objection? What is the delay? Why there was delay of 419 days? What is the explanation?
An objection was filed on behalf of the.
Okay, we will see to the objection. First, you tell me, what are your grounds?
Only due to the financial hardship.
Huh?
Because battling financial hardship, Your Lordship.
Battling financial hardships.
And of course, one thing is one point is very clear that he has no understanding of the law, Your Lordship. He's going to be held from the village area, Your Lordship. Had he known the process of law, he wouldn't have done that, Your Lordship.
Sorry?
Had he had known the process of law, Your Lordship, the knowledge of law, that the petition should have been filed.
Alright,
before
let
the-
us see how you have made the averments. You can read out the grounds.
Your Lordship, regarding this I want to just submit that an objection was filed on this IA. There was some typical error mistake by my learned counsel in it. There's from paragraph 1 to I have the paragraph 1 to point number 8, Your Lordship. An additional affidavit may be allowed to file in this regard, Your Lordship.
For what?
Over, Your Lordship, Kindly use, you see your.
We will go to all that later. Mr. Counsel, it's a condonation matter pending from 2019.
Yes, your lordship.
I'm not adjourning this matter or going into more pleadings.
Yes, your lordship.
Please tell me where are your grounds?
Counsel, lordship.
We'll go to the objection if need so, but first you show me
The
that you
criminal
have
provision petition, the
whether you have
petition,
grounds or not. It's a quite a long delay. Delay will not be condoned as a matter of course. You have to make out a case. Let us see what case you have made out on affidavit.
Yes, your lordship.
Come to paragraph 3 of your IA.
Yes, yes, yes. Your
Why are you taking so much time?
lordship. Pardon me, lordship.
Paragraph 3.
Don't be nervous. You're doing
I'm
good.
sorry, your lordship.
Just come to your IA.
Yes, your lordship. Just taken out, your lordship.
Paragraph 3.
Paragraph three. Yes, your lordship. Read paragraph 3.
Yes,
When
read.
this petition was made, your lordship.
Yes, read.
Yes, the applicant of the oblique appellant respectively states that immediately after passing of the aforesaid judgment, an order dated 25/10/18, the applicant was transferred to jail custody. This was a mistake, typical mistake.
No, it is here 8/1/19.
Yes, yes, 8/1/19, your lordship, but in this petition. the witness
Which
identified-
petition? Miss Bora, I'm not being able to follow. Where is he reading from? Because I have the petition, I am reading it.
Lordship, it's, he's taking the IA 621,
6/1, your lordship.
2019.
Yes, IA 621, paragraph 3, the date is 8/1/2019.
Lordship,
8/1, yes, 8/1.
Lordship, it should be 8/1, 2019.
It is
Yes,
8/1/2019 in
yes.
my copy.
It's
Yes.
there, Lordship.
Pardon, your lordship.
In your copy, it is not.
Yes, it is written in pen, your lord, by writing the
There's
pen.
some minor mistakes.
It may be done by mistake.
No, that you ignore. You read now. Read it as
Oh.
8/1/19.
Yes, your lordship.
Is that the correct date or not?
Yes, correct, your lordship.
Okay, read.
8/1/19, the applicant was transferred to jail custody, your lordship. The
Huh?
applicant, because of remaining confined within the four walls of the prison, could not
So
regularly.
why it is? Hey, to dekhai diok.
It was mistake হৈছিলে. If
Mistake
typical mistake.
to
The
yaar
last
ekho
objection,
nai.
this was hard, your lordship. Regarding typical mistake, typical mistake হৈছিলে.
So you want to go for correction?
Yes, correction, your lordship. Only from paragraph 1 to paragraph 8.
But why you did not make that prayer there? But there is no mistake here. Please read in my copy.
That the applicant appellant respectfully states to size order. States that immediately after passing of the aforesaid judgment and order dated 8/1/2019, the applicant was applied
Oh, there's
For-
some
Yeah,
words
yes.
missing.
Yeah.
All right, okay.
So he wants to go for some correction.
Yes.
Mister, your name?
And Millie appearing on behalf of R. Chitri, your lordship.
Mr. N.
Millie.
Millie.
Yes, lord.
Mr. N. Millie, learned counsel for the applicant submits that due to oversight, there has been some typographical errors in the averments made in the interlocutory application and accordingly seeks accommodation to do the needful. Prayer is allowed. List after 1 week. 1 week time I'm giving you. You do whatever you have to do.
I will.
Data condemnation petition, a separate petition has been furnished to us, Lordship.
I know. There has been some errors. So it's all right. Let him do the correction. We let him file whatever he wants to file. Then we'll see. Okay, you will get your opportunity. Relist after 2 weeks on a date to be fixed by the registry.
Highly gratified.
You do whatever is to be done. I
Okay.
have not said what is to be done.
I will definitely.
So either you file an amendment, probably you'll have to file an amendment. Because the whole paragraph is, you can't just simply correct it.
Yes, Lordship.
You have to file an IA for correction
Correct.
or for.
From paragraph 1 to only 8. The rest are always.
So that is why
to go
therefore
for a
you,
fresh one.
I am not going to advise you, you see what is to be done in accordance with law, otherwise she is there to
Your
object.
lordship, yeah.
Except that first title, everything is regarding a criminal appeal. Something criminal.
So that
appeal.
means the entire, it must have been copy paste. I think it is the, it is because of that. All right.
I'll get it back.
For hearing item numbers,
Yes, Mr. Gautam,
Lordship, that consent to establish the water act, matter, Lordship.
I have forgotten.
Today also, Lordship, the respondents are not present.
I have forgotten everything.
They are on legs.
All right, another day.
Sometime in April, Your Lordship.
In the release in the month of April, so and so, Taragat, your name,
D. Datta, appearing on behalf of S. Purva.
MS,
MS D. Datta.
D. Decca, Learned
Datta.
Council, appearing on behalf of
S. Purva.
Mr.
for
S.
producing
Borwa,
the-
Learned Standing Council.
Yes.
Pollution control.
Pollution Control Board submits that Mr. Borwa is occupied in another court in another court and accordingly seeks accommodation. Prayer is not opposed. Released in the month of April on a date to be fixed by the registry.
Lordship.
item number 7 and 8.
Lordship, apologies, Your Lordship. There's an interim order, Lordship. that is-
Interim, if any, shall continue to the next date of listing.
Lord, in this case, in both the cases were heard by your lordship. And I had submitted the written argument, but however, on the last occasion, the lordship has returned me back to make out some correction. The only correction was that the writ petition numbers were incorrectly recorded. I will just handle it.
Mr. Chakrabarti, you have given
I
your
have also,
argument.
sir, I have also filed.
Argument before that. Okay. Yes, sir, argument. Yes, you can refresh.
So my lord, what happened in this case, here, both these writ petitions are against an award of 21/12/2017 passed by the presiding officer, Labour Court, Dibrugarh. Now, the issue before was, the Labour Court was whether the management was justified in releasing the workman before his actual age of superannuation.
Where do I get the,
In my
reference?
written argument, I have given the paragraphs and the page numbers, my lord. The award your lordship will find at page 78 of WPC 22
in next,
2996.
both are filed by you?
No,
No, Lordship, both the parties challenge that award.
Now-
2996 is by you?
by me, the management, because we are aggrieved by the last part of the award
Alright.
where
Award is at page?
it starts from page 78.
Yes.
And we are aggrieved by the direction issued at paragraph 19 of the award, which your lordship will find at page 90.
Yes, please read.
The management is a local authority. Now, before that, the court finds that the release of the workman was good because he attained the age of superannuation. Then the court gives a direction.
Where
The
is
management is
that?
a local authority.
Where is that finding?
Now, my lord, paragraph 19, I'm the part which we are aggrieved.
No, the other view. That the release is good.
Because paragraph 18, I am of the view that the delinquent employee, so and so is not entitled to reinstatement in his service with full back wages and other consequences benefits.
Okay.
Now here we are agreed. The management is a local authority. The terms and conditions of the employment of the employees are governed by the statute and statutory rules. Similarly, the retirement of the employees is also governed by such statute and statutory rules. There was no domestic inquiry held, though it is the most important one in case of any dispute between the employee and the employer, knowing well that the employee is a weaker party in the industrial relation. Thus, it is at most important for the employers to carry out the inquiries in accordance with the principles of natural justice. It reveals from the record that there was no domestic inquiry held in connection with the instant case.
So you are aggrieved by this
Yes.
compensation, 1
Yes.
lakh.
My lord, in a case where a person
is released from service on attaining the age of superannuation, where is the requirement of holding a domestic inquiry? And
What is the reference?
my lord, it was raised by the workman under 2A.
Where is the reference?
The issues your lordship will find at
No,
page
this is
70.
a reference case or,
A dispute was raised, but the workman went under 2A,
so it is not a reference.
not a
case.
reference. 79, whether the management of so-and-so tea estate is justified in making
Premature retirement.
premature retirement. According to us,
This is not stigma, punishment or anything.
so there is no question of holding any domestic inquiry. So to that extent, we are
No,
agreeing.
but why premature retirement? Where is the provision for
No, it
premature
is not
retirement?
premature retirement. Our case is that he attained the age of superannuation according to the record maintained by us.
That is your case.
Yes,
And
and
what is the finding of the labor code to that?
yes, that age is correct.
Where is that finding?
Paragraph 16, page 89. I have carefully shifted the evidence and records considering the records. Considering the evidence and records, submission of the learned counsel both
No,
sides. and
before
reliance-
that, let's see para 15.
I have also heard the arguments of both sides. The learned counsel, while arguing for and on behalf of the workman, has submitted that so-and-so and Mangra Etwa and Bango Munda. Because my lord, he is named as Mangra Etwa. But the school certificate which he produced before the court during the proceeding shows that one Bango Munda. So it was questioned, how can there be two persons? Now, in that case, may I take your lordship's notice to that evidence?
Chakraborty, first, please read
yes,
para 15. You submit
At
later.
the one and the same person, and in this connection, the workman has already submitted his school certificate, Exhibit 1. He has also filed an affidavit, Exhibit 2, in this connection, stating that his date of birth is so-and-so and not 1154, and therefore he should be retired on 23/8/26, and prayed to set aside the notice of retirement, Exhibit 3, and also reinstate the workman with full back wages and consequential benefits. On the other hand, the learned counsel while arguing for and on behalf of the management of so-and-so has submitted that Bango Munda and Mangra Etwa are not the same person. He has submitted a false school living certificate and an affidavit in connection with his date of birth. The date of birth of Sri Mangra Etwa is 1/1/1954 as per official record of the tea garden and as per the PF nomination form duly signed by the workman, Sri so-and-so. In census checklist, the workman's date of birth is mentioned as 1/1/54, which is a computer generated document. The learned counsel for the management has further submitted that in every document, the workman has mentioned his name as Mangra Etwa and not Bango Munda. The workman made his affidavit on 2011-2012 after getting the notice of retirement. At the end of his career, the workman is challenging his date of birth, which is not acceptable. In all office papers, he has signed and mentioned his name as Mangra Etwa, not Bango Munda. In the initial petition filed by the workman name is recorded as Mangra Etwa and not Bango Munda. He has not even mentioned in the original petition that Mangra Etwa and Bango Munda is one and the same person. In his voter record, his name is mentioned as Mangra Etwa and not Bango Munda. The learned counsel for the management has submitted that the school living certificate submitted by the workman is of someone else. The workman is trying to mislead the court by producing a wrong school certificate. If at all his date of birth was wrongly entered in the record book, office record, then why the workman did not correct it within 3 years from his appointment? The workman is not entitled for any back wages for reinstatement as paid for. The learned counsel for the management in support of his contention place relies on so-and-so, so-and-so.
All right.
My lord. And then he has said, yes. I
Yes,
hold.
Mr. Chakraborty, what is wrong with this?
Now, my lord. If it finish. Oh,
No, Mr. I am with you for the moment.
my lord.
I'll come back to you if needed. What is wrong? What is the error?
Lordship.
You have come in what? Tertiary.
Lordship,
This is prayer is what? Tertiary.
in my petition, Lordship. Yes, Lord.
Tertiary. Then what is the error? Please point out the error.
Lordship.
Lordship, may kindly go through Rule 76 of the Assam Plantation Labor Rule.
Yes.
But if that is on record now. नहीं, एक print out to like your पाई जाओ, edit as a network.
You should have had a copy.
No, last time I provided, Lord, ought to be in the record, Lord. Anyway, Lordship, the form I have annexed to my writ petition, that form, last page, page
Wait,
73, page 73 of writ petition, Lordship, 6540. The last page.
Which is your writ petition? 6540.
6540.
Which page?
Last page, Lordship, 73.
No idea. Also, नाम तो पूरी
72 and 73 both are relevant, Lordship. These are the two forms which ought to have been maintained as per Rule 76 of the Assam Plantation Labor Rules, in which the age is there, Lordship. Age, date of entry in service, age, land.
What do you want to show from here?
If they could have produced that before the land labor code, that
No,
would be
no,
the
no.
of the matter, Lordship. What they have produced, Lordship, the PF form. That PF form, Lordship, will find at page. Page 66. Page 66.
This is what they have.
They have produced. It has no PF, Lordship, no. Page 67, Lordship, may kindly come.
Page?
Page 67.
67.
66 and 67, both they have relied. 67 is without any number, without any date. Serial number missing. No date is there. How that can be relied, Lordship? When the best evidence is what been had, and what they have stated, Lordship, in the evidence, in their cross. May just read two parts, Lordship. This one of the management witness, Lordship, Utpal Sharma. He is the
Page.
page 49. Page 49, 1, 2, 3. The three line from the bottom, Lordship. Page 49 of my writ petition.
Yes.
Three line from bottom. Service file of employees is kept till retirement. Census checklist is prepared every day as per census record. Any of the ex-servants so and so. The daughter of son, the particular main not be used, the about surname, he has also said that. Then, Lordship, I do not know if Sri Mangravata born in our service record of the workers was made by another staff in those days, as not in the T state. Then another witness, Lordship.
What did you want to show from here?
Lordship, page 45, Lordship.
Page 50. What is that you're trying to show from here?
Lordship, page 45. This is the manager who have adduced evidence as MW1.
Yes.
I have joined in my service on 15/3/24 as welfare officer. Thereafter, I have been promoted so and so. I know the rule 1 of rule 6, Lordship, the third line. I know the sub rule 1 of rule 16 of the Assam Plantation Labor Rules 1956. I know about the form number 8 of the rules of Assam Plantation Labor Rules. In column 2 of the form number 2, the name, age, and address of the worker is to be recorded. I have not submitted in the court the copy of workers registered in which all biodatas of the workers are recorded. It is mandatory to keep such record in every T state. Why they have not produced that, Lordship? And
At
Lordship.
2.
Lordship.
At 2.
Lordship. আজকে তোমার দরকার নেই
It's surgery.
Lordship. Where is the scope of
If the
reappreciating?
if the relevant evidence has not been considered, that's the point of lordship can
That's the
exercise.
point of law.
If evidence has been overlooked,
It,
lordship,
the judgment has been already, that operating part of the judgment is read out.
lordship.
It is apparent that evidence is gone into. There is no dispute that at that time you have not objected.
Lordship, page 58, paragraph 12 of the judgment.
Page,
58 of my writ petition,
yes,
paragraph 12,
show out from the judgment if there is a patent error.
lordship. May I read, lordship?
Page 58.
58, paragraph number 12.
Yes, please.
In his cross-examination, MW1 has further stated that he joined in service and so as a welfare officer after he was promoted to the post of assistant manager. He has not submitted the copy of workers register in which all biodata of the workers are recorded. The management has submitted the census checklist prepared by the management. The date of birth of workman is recorded as 1154. Date of birth of Bahamoni Mangra, daughter of workman, is recorded as 1196. Date of birth of Magan Mangra, son of workman, is recorded one. So everybody in my family is born on 1st of January, lordship. The date of birth of Mrs. Marsa Mangra, daughter of work, is recorded 1193. Etwari Hindu was the wife of workman. Her date is, so everybody in my family is 1st of January, lordship.
That is not a patent error.
Lordship.
That cannot be a manifest patent error.
But the court admit that the register has not been produced.
That's all right. That you see, you're repeating that thing.
If what
You have shown that under the plantation rules, it is mandatory for the management to maintain a register. You have shown it. Then you have also
if that has not been produced,
correct. But you see, now that is not the issue here. The issue is whether the management is justified in prematurely retiring the person in question. Their case is that he has already attained superannuation, age of superannuation as per the available records, and accordingly it has been done. Your case is that when you received the notice of retirement, you had brought it to the notice by filing an application that is not the correct age. This is the factual facts. There is no dispute to these facts.
but the
Right. Now you are saying that it is they have not done it in a manner which they should be done, number one. Number two, you are saying that which is that pension document which they have relied, which you have shown me?
Page 66 and 67.
Page
66 and 67.
Now here,
there is no date, there is no PF number.
no, but your signature is there.
My signature is there. I have stated in my
Your
affidavit that
signature is
they
there.
have taken in some blank form.
The date of birth is mentioned 1154.
I have stated they have taken a signature in blank form.
You have said that in the affidavit.
Yes, lordship.
Not earlier to that.
Lordship.
I
can raise my dispute only after this, lordship.
But a blank form, you could have always said it. Why did you sign it in a blank form?
Lordship, if the best evidence has been kept away from the court, lordship. Adverse inference has to be 114
best.
114G.
You see, Mr. Chakrabarti, the document at 67 itself shows that your date of birth is 1154 and you
But
have
why
signed
not the plantation level?
Now, this is a factual aspect which the labor court has gone into it and on the basis of evidence has rendered a judgment. I do not see any palpably manifest error in the decision of the
Lordship,
labor.
a little lower in the same paragraph. May I
See,
read?
I am only expressing my so that to
Tentative opinion.
yes, and
It
so
may
as
change,
to
it may.
correct. So as you can reply
Lordship,
and you can change
Lordship,
my
the
mind.
same paragraph, little bit, Lordship. May I read just, Lordship?
Yes.
All date of birth has been given recorded. Same paragraph, page 59. Page 59. Page 59.
Yes.
Same paragraph.
Yes.
All date of birth has been given recorded of the workman family members. MW1 has denied of wrongly recorded. In Exhibit D, it is not shown on which date it was filled up. PF number is also not shown. The management has not submitted the appointment letter of the workman. The leave book has also not been submitted in the court. The management has not furnished the form number 11 to the workman. Management witness has further denied of wrong. So if all these are not been, how can the Labor Court could have come to the conclusion, Lordship?
All
The
right.
best evidence has been kept away from the court, Lordship. So the adverse inference has to be under 114 of the Evidence Act, Lordship. Note to him in my favor, Lordship. That is my submission, Lordship. The best evidence has not been proved. Now, Lordship, may come to page 60, Lordship. Paragraph number 14.
Yes,
May I read, Lordship?
yes.
In his cross-examination, MW2 has further stated that he knows Mangra Etwa, who was a permanent sub-staff. He also knows wife of the workman has died. He also knows his daughter. He joined in service in 2008 at Bogapani Tea Estate. There are the trade unions, namely ACMS and BCMS. Appointment letter, medical certificate, nomination form, PF form are recorded and kept in proper file. At the time of appointment, they generally accept the school certificate in support of the age of the employee. In the absence of birth certificate, when the workman was born in the tea estate hospital, the attending doctor of the tea estate issued birth certificate. So any of them, they could have produced, Lordship. They have not produced anything, Lordship. I may have produced one school certificate that may not be proper because the author of that has not been examined. I do fairly admit that the author has not been examined. So whether that could have been taken, but I had at least produced something, but they have not produced the best evidence which they are keeping in there. That is my case, Lordship. What is under the plantation levels, because plantation levels is Bible so far as tea estate is concerned, Lordship. That ought to have been produced, Lordship. That is my case, Lordship. And I'll be relying on the Lordship that since I have filed a written argument, Lordship. Can you look? My case is based on that, Lordship. So in my humble sense, was the conclusion done by the labor court that is overlooking the evidence, Lordship? Has not
And in
supported.
that, the other thing is that school certificate which you have produced, that
Name.
also has a different name.
So far as that, I have submitted one affidavit also before the labor court, Lordship, and exhibited that.
And you have stated in your evidence that that name is only mentioned in that school certificate and nowhere else.
Not only different names, others' names are also different.
You see, there is no, you are correct that the
That's why
management, you are correct that the management ought to have maintained that register in terms of the rule. But not maintaining of the rules would not be of any help to you as far as this case is concerned. Because here, as far as this case is concerned, there are evidence which indicates that your age is of 50, the date of birth is of 54.
That conclusion has been drawn from only from the PF form, Lordship.
Those have been,
whether that could have been relied.
those have been, you see, now if there are two views, because of two views in exercise of certiorari jurisdiction,
In view of the what
is not going to go.
In view of the what has been recorded in paragraph 12, Lordship, whether that could have been arrived at.
That is not the finding of the court. That is what is come out from the evidence.
If that was in the then
Paragraph
it is
11
apparent that
is
this
not
has
the
been
findings
overlooked.
of the court. The findings of the court, court starts from para 15.
Lordship.
Please read from para 15. Para 15 is the findings of the court. Those,
Lordship.
please don't let us be pragmatic in your submission.
Lordship.
Para 12 is part of the evidence, cross-examination.
If that vital part has been overlooked,
Read 15.
Coming to the conclusion.
Please let us see what is the finding of the court.
I have also heard the argument of both the sides. The Land Council, while arguing for and on behalf of the workman, has submitted that Ten Bangamunda are the one and the same person. And in connection with the workman has already submitted his school living certificate, Exhibit 1. He has also filed an affidavit, Exhibit 2, in this connection, stating that his date of birth is so-and-so and not, and therefore he should have retired on and prayed to set aside the notice of the retirement and also reinstate the workman with full back wages and consequential benefits. On the other hand, the Land Council, while arguing for and on behalf of the management, submitted the Bangamunda and Negamunda are not the same person. He has submitted false school.
The labor could have also taken action against you under section 190 CRPC for filing false document, manufactured document.
Now that was the only submission of that land court below has not.
But
the date of birth of Mangra is so and so as per the official record of the tea garden and was as per official record. What is that official record, Lordship? That could have only the PF form, Lordship. And PF form doesn't boost confidence.
But you see, that is a document of the tea garden. It is not some
But
Third
what is
party document.
but what is mandatory under the plantation
Could
that
be,
has?
you may have a point, but that itself is not sufficient. Because the school certificate which you have produced bears some other name.
Now, whether lordship, this census checklist and the PF form could have been there.
Then read ahead.
The land council for the managers further submitted that in every document, the workman has mentioned his name is Mangra Atwa and not Bango Munda. The workman made his affidavit after getting the notice of the at the end of his carry. In all of his paper, he
I
has,
think the workman also agreed, no, that his name as the other name is only in the school certificate.
That's-
I think he has admitted that.
that's, but
Yes.
lordship, what is the evidence produced by the management that doesn't boost
You have
confidence?
to build your case on your evidence. You
Lordship.
forget the evidence of the management.
But-
I could have understood if management has not produced the
Lordship.
PF and the census.
Lordship,
Then of course you have a point.
lordship,
But they
I am
have
a-
at least shown that.
lordship,
And you are not saying the age is not wrong because you yourself have filed an application for correction.
lordship, I am fighting before a management lordship. I am at a beginning
You
end.
filed an
lordship.
application for
Yes,
correction.
they could have produced the best evidence, lordship, which are not.
And you could have made a prayer before the labor court
That's
for calling for this register.
No.
Why you did not make that prayer? What prevented you from making
Not-
that prayer?
That's true, lordship.
Have you made this argument before the labor court? I don't find any argument on this.
Lordship,
First time you're making
Let-
this argument before
let my
this
friend
court.
submit.
That also
I'm
on-
fine- I'm
In a
trying to fi-
tertiary jurisdiction.
Lordship, I'm trying
How
to find
can-
out whether
How
that,
can you say that is a manifest and a palpable error on the face of the record when you have not argued this point?
if that was to call for, lordship, may just check out, lordship.
It's not
moment.
there.
For a moment, lordship may take up my written argument. I have clarified his argument regarding form 8 and 10.
Mr. Chakraborty, first let him finish and then I'll come back. You in your reply, you have a right to reply. You reply at the end. Labor Court Action Rules.
So far as name, lordship, my explanation has been given at page 31, paragraph number 3.
No, Labor Court or Rules and Act. Which is that provision in the Labor Court rules which says
76.
for evidence and documents, it will exercise the powers of the civil court. Yes, Mr. Sharma, you remember that rule? That labor, I think it's in the rules for Labor Court. In relation to taking evidence and documents, the court will exercise the powers of a civil court. You remember that?
Section 10.
Industrial Disputes
Section
Act.
10, Section 10.
Act Kondiok or rules?
Section 10.
I think rules, rule 26. 26. All right, thank you. ID Act Kondiok or rules to do?
154 to 154.
Lordship, yes, my friend is correct, 11.3.
Yes, please.
11.3, lordship.
11.3, please read.
Every board, court, labor court, tribunal and national tribunal shall have the same power as they are vested in a civil court under the Code of Civil Procedure when trying a suit in respect of the following matters, namely enforcing the attendance of any person and examining him on oath, compelling the production of document and
Yes,
material object.
compelling the production of documents. What prevented you from making this argument before the labor court? (11A). Yes, anything else?
Lordship.
Yes, Mr. Chakraborty, you wanted to add anything else?
Yes, my
Otherwise,
lord,
I'm ready to dictate.
My lord may have a look at my written argument, page 4 of the written argument. Here, our response to the argument that regarding Form 8 and 10.
Yes.
Now, if the lordship looks at those forms, which other, which comes in page number 70.
No, the council representing, you are reading from there.
Yes, yes. The council representing the workmen has argued that the management had not produced Form 8 and Form 10 maintained under the Assam Plantation Waiver rules before the Labour Court, and for that, the learned court below ought to have drawn adverse inference against the management. In response to this, the management would like to submit that Form 10 is a register of leave of with wages of workers, and Form 8 is a register of adult workers. In both the forms, there is no provision column for recording the date of birth of a worker.
Only
Although
age. Only age.
Age in, no, so for 10, there is a leave register, there is nothing, and 8 is age. And that age is for the purpose of recording the number of adult workers engaged in the gardening. If your lordship
Form numbers are form numbers.
10 and 8, your lordship will find form number 8 at page 73 of this rate petition.
No, I think it is there here.
Yes,
Form number
72,
8.
page 72 is form number 10.
Form
So it is
number
register of leave with wages.
8 is there.
Here your lordship,
Name, age and address.
yes,
Certificate of sickness. Sorry, register of adult workers.
yes, adult
Here,
worker.
he was not an adult worker
Right,
at
he
that
was an
time.
adult worker. So it is A, and the purpose for maintaining him
And which is
to-
the other form?
and Form 10 with at page 72, there is no provision to record the age or
Register of leave wages.
page 72.
রূপক একটু উল্টা পুল্টা কি আছে ঠিক করে দিয়াছেন মানে গম পাবা তাহলে এটা ঠিক করে দিবা আৰু এই 10 তো এটা এই লগাই দিয়াছেন পোস্টেড all right.
Now, my lord, another aspect is, it is not even the pleaded case of the workman before the Labour Court or before this honorable court that the date of birth or whatever the age is different in that form. Lordship may turn to the next page of our argument, written argument.
Yes.
Moreover, it is not even the pleaded case of the workman that the age of the workman recorded in Form 8 would have clearly demonstrated that his retirement on 31/12/2012 was unjustified. He did not even call for those documents. And my lord,
Did not call and wants this court to now draw adverse inference because you
it
have
is not
not.
permissible, my lord.
That cannot be. Nobody stopped them from
And
asking.
my lord, the question was, he was retired on the basis of a document. Now, it is his case that date of birth is wrongly recorded.
So the
Now,
onus was on him.
Onus was one.
Anyway, I don't think I need to go so much into it. It's a limited jurisdiction.
My lord. So,
All
my
right.
respectful submission is there was nothing
Okay.
adverse. This is a finding is not perverse. It is only perverse to
now
the
you
extent of
Please hear me out. If there are anything needs to be added or corrected, please later on you can just tell me. All right, both of you. Into item number 7 and 8. Na? Heard Mr. S. Heard Mr.
My lord, I'm for
1 second. I'm getting confused with whenever there are two writ petition, it's very difficult. Heard Mr. B.
Yes, sir.
Chakraborty, Learned Counsel, appearing in WPC 6540
Of
of 2018, and Mr. S. Chakraborty, Learned Counsel, appearing for the petitioner in WPC 2996 of 2018. Stop. Nobody else, no? State is there. Formal party or not formal party?
it is a party. Note the writ petitions.
Also heard, no, also, should I also mention that a B. Chakraborty, petitioner in 6540 and respondent number in 2996.
In my petition, respondent number 2.
Respondent number 2 in WPC 2996 of 2019. For September to say Also heard Mr. S. Chakraborty, petitioner in 2996. Aru, respondent number?
1 in the other.
Respondent number 1 in WPC 6540 of 2018. Also heard, state is there.
In my writ petition, state is respondent number 2.
Who is appearing? Anybody, government of Assam? Get hold of someone, I'll give a name.
Lordship may record anybody's name from the panel. Uh,
Can you ask for someone from the government? Who? Bench 3, I think this is bench 3 matter, whoever the panel councils are. Also heard, Mr. So-and-so, learned government advocate for the state respondent in WPC 6540 of 2018. In your
Yes.
petition, government is not there.
No, is that respondent number 1 and 2?
And respondent number
1 and
1 and 2 in 2996 of 2018. Both the writ petitions having arisen out of the award dated 21/12/2017, passed by the Learned Labour Court Dibrugarh in reference case number 1/2015, which was published on 5/3/18, by memo number GLR 32/2018/6/2016, common. Is taken up together for final disposal. And governmentor M. Chakraborty, M. Bhattacharjee, learned additional senior government advocate, not government. All right. The brief facts of the case is that the petitioner in WPC 6540 of 2018, hereinafter referred to as the workman, was appointed as sub-staff at the tea estate of the respondent tea estate in the year 1986. Kami workman or respondent tea estate military. At the tea estate of the respondent number 2 in WPC 6540 of 2018, within bracket, hereinafter referred to as the respondent tea estate. While working as garden, thereafter, the workman was promoted to sub-staff grade 2 with effect from 1/6/2007 by order dated 22/5/2007. Upon attaining the age of superannuation, the respondent tea estate issued a notice of retirement to the petitioner, to the workman, indicating his date of retirement to be 31/12/2012. It is the specific case of the workman that 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 he having that that his date of birth ought to have been 1154 instead of 24/8/1968. No, sorry. Ought to have been 24/8/1968 instead of 1154. And accordingly, approached the Assistant Labor Commissioner, Tinsukia, seeking a stay of his retirement on the ground, on the saying stay of the of his retirement. Stop. In support of it further it is accordingly, conciliation proceeding was initiated by the labor authorities, but the dispute could not be settled, for which the workmen filed an application before the labor court at Dibrugarh under section 2A within bracket 2 of Industrial Disputes Act 1947, hereinafter referred to as the Act 1947, which was registered and numbered as ID case number 1 of 2015 by the before the labor court. Before the labor court, both the management and the workmen, both the management and written statement and the workmen had filed their respective written statements and have adduced evidence after the evidence was after closure of evidence, the labor court after hearing the parties was pleased to pass the award whereby it was held that the management is justified in retiring the workman on his superannuation. However, the labor court was of the opinion that, the labor court was of the opinion that since no domestic inquiry was held, the management is liable to pay compensation to the workmen and accordingly directed the management to pay compensation of rupees 1 lakh to the workmen. Stop. The petitioner situated thus, the petitioner filed WPC number 2996 of 2018. No, filed 6540, sorry, 6540 of 2018. Challenging the award of the labor court in respect of issue number 1, which is held in favor of the management, and the management filed WPC number 2996 of 2018 against the direction passed by the labor court directing the management to pay the compensation of rupees 1 lakh to the worker. Stop. Correct?
Yes.
Stop. Mr. B. Chakraborty, learned counsel, appearing for the petitioner in WPC 6540 of 18, submits that under the Assam Plantation Labor Rules 1956, in terms of Rule 76, it is incumbent upon the management to maintain registrars and and record the name, age, address of the workmen in Form 8 and 9 thereof. He further submits that in the present case, the management having not produced the Form 8 and 9 as required under the rules, adverse inference be drawn against the management. He further submits that the school certificate produced by the workman bears the correct date of age, and though the name in the said certificate is recorded as Bango Munda within quotes, instead of Mongra Itwa within quotes, the two names are one and same, i.e. the petitioner, and therefore the labor court ought to have accepted the said certificate and the affidavit filed by the workman in this regard. He further submits that the PF nomination form relied by the management. আমি তেখেতক in petitioner কোৱা জেগাত for workmen কৈ দিয়া তেতিয়া মিলি থাকিব B. Chakraborty appearing for the workmen. Okay. Relied by the management, showing age of workmen, showing the age of workmen recorded as 1154, ought not have taken into consideration, as the workman in his evidence in chief clearly stated that his signature in the said PF nomination form was taken in blank form and the blank form. Stop. He further submits that in the census checklist relied upon by the management, the date of birth of all the family members of the workman is strangely shown to have born on same date, i.e. 1st of January of different years, and therefore the same is highly doubtful. Per contra, Mr. S. Chakraborty, learned counsel for the management, submits that there being no unreasonableness in the findings of the labor court, the award of the labor court ought not to be judicially interfered by this court. Stop. He further submits that the Form 8 and Form 9, Form 10, sorry, are the register of adult worker and register of leave with wages of workers respectively, and there is no provision stroke column for recording the date of birth in the said forms. He further submits that, however, in Form 8, there is a column for recording the age of an adult worker. He further submits that it is not the pleaded case of the workman that the age of the workman recorded in Form 8 would have clearly demonstrated that his retirement on 31/12/2012 was unjustified. He further submits that the workman, workman did not call for those documents. Did not call for the subject Form 8 and Form 10 from the management during the proceedings before the labor court. He further submits that since the workman has disputed the age recorded in the official record maintained by the management, the onus was on the workman to prove his case. He further submits that the principle that in connection with the school school certificate, comma, the school register as well as the principal of the school who had issued the certificate, having not examined, the same is not admissible in evidence. In connection, in support of the aforesaid submission, he relies upon a decision of, this is of our High Court,
Just one.
of the division bench of this court in the case of Chandiram Burman versus Union of India, reported in WPC number 2328 of 2019.
In page 3, we have pointed out his admission of signature in the PF.
Hmm.
In the page 3 of the written argument, we have pointed out the admission of the workman regarding his signature in the PF nomination form.
That he have said, blank page.
But no, that he has said blank page, but we have said that in his cross-examination, he has admitted that he has signed.
He further submitted that the workman in his cross-examination admitted that the signature in the PF nomination form is his own signature. So, I have heard the submissions of the learned counsel appearing for the contending parties and have perused the material available on record. I have also considered the citation, the case law cited at the bar. Mr. Chakraborty, you are relying on this Karnataka rural infrastructure case.
No, it is, I'm relying.
You are relying.
I'm not the site, need citation notes.
No such. But then why in your submission this is, oh, I think by mistake I have put it in your submission. All right. And take it out, case laws. In support of the aforesaid submission, he relies upon the following decision. Number 1, Yapra Sailoba, Karnataka Rural Infrastructure Development Limited. Karnataka Rural Infrastructure Development Limited. A written arguments of Paijaba, Pakikini Praidiva. Chandiram Burman to Dilu. Episode 2019, volume 18, SSC 39. 2019, volume 10, SSC 738. 2016, volume 2, GLT 874. It appears, it appears that the Labour Court issued the following frame the following issues for determination. 1, 2, 3, 4, page 52. Thereafter, both parties adduce their respective evidences and cross-examined each other's witnesses. It appears that the workman, by producing a school leaving certificate dated 2010-2012, wherein his age was recorded as 44 years, 5 months. Contended that his age is not 58. His age therefore could not have been 58 as claimed by the management. It appears that in the said in that school leaving certificate, the name of the petitioner is mentioned as one Bango Munda instead of Mangra Itwa. It further appears that the workman filed an affidavit on 2012 clarifying that Bango Munda and Mangra Itwa is one and the same person, that is the petitioner. It appears that the management in its written statements filed before the Labour Court had pleaded that the workman joined the garden on 21/3/1986 and in his PF nomination form, his date of birth is recorded as 1/1/1954. It appears that accordingly, he was retired from his service on 31/12/2012 on attaining the age of superannuation. It appears that the workman in his entire service career had never challenged his date of birth, and only at the fag end, he has questioned his recorded date of birth by producing one school certificate. From the evidence available in the record of the court, from the record of the Labour Court, it appears that the workman in his cross-examination before Labour Court has admitted the fact that during the period of his service, he did not submit any document in relation to his age and also did not apply for correction of date of birth in the garden record. He further admitted that the signature in the PF nomination form is his own signature. He further admitted that he left the school in the year 1981 and procured the school certificate in the year 2012 and collected the certificate after receiving the notice of retirement, and Bango Munda is recorded in school only and not in any other institution or organization. Stop. It appears that the workman did not examine anyone from the said school to prove the certificate and its contents, as well as the school record wherein the date of birth as claimed by him was recorded. Rule 76, right?
Lordship.
Apt at this juncture to refer to Rule 76 of the Assam Plantations Labor Rules 1956. Hereinafter referred to as the Rules 1956, which is reproduced hereunder for ready reference. 76A to A, huh? Yeah, that's it. Reading of the aforesaid rules, it appears that the employer is required to maintain registers of adult and non-adult workers in form number 8 and 9 appended to the said rules, respectively appended to the said rules, and a register in form number 10 here in 10 in connection to the leave with wages in connection to leave and wages. Form number 8 and form number 10 is also extracted here under for ready reference. Perusal of the aforesaid form, it appears that there is no column provided for recording the date of birth of a worker in the said forms. It further appears that in form 8, there is a column for recording the age of an adult worker. The argument of Mr. B. Chakraborty, learned counsel appearing for the workman, that the form 8 and form 10 are vital documents which ought to have been produced by the management before the labor court in support of their contention, in support of their contention as regards the age of the workman, is totally fallacious inasmuch as on the face of, inasmuch as the said there is no column for recording the date of birth in the said two forms. And rule 26 and rule 76 further clarifies that these are registers of adult and non-adult workers and the leave and for leave with wages. So, be that as it may, it is admitted that the workman has neither prayed before the labor court for calling these two forms for directing the management to produce these two forms, nor argued the same, nor taken the said plea, nor taken the said plea. It is, in fact, the workman has taken up the plea relating to Rule 76 and the said two forms for the first time before this court. Apt to refer to Section 11, capital A of the Act of 1947, which reads as hereunder, quote unquote. Perusal of the aforesaid rules abundantly clarifies that any party to the proceedings clarifies that Was it 11A?
11A.
11?
11A. Not 11 sub section 3.
3, sorry. To 11A নহয় দেই. 11 subsection 3 কৰি দিয়া. Quote unquote দেই. Amply clarifies, amply indicates that the labor court is vested with the same powers as that of civil court under the CPC civil procedure, under the Code of Civil Procedure 1908, while when trying a suit in respect of inter alia compelling the production of documents and material objects. That being so, the workman could have clearly made, that being so, nothing prevented the workman from making an application before the labor court at the relevant time for seeking direction to the management to produce the Form 8 and Form 10 maintained under the rules so and so. Having not done so, it is not open for the workman to contend before this court at this stage that because of non-production of the aforesaid two forms by the management before the labor court, adverse inference has to be drawn against the management. Stop. It appears that based on the evidence, the labor court recorded the finding that the management was justified in retiring the workman on attaining the age of superannuation on 31/12/2010 and rejected the contention of the workman that his date of birth is 24/8/1968. Operative portion of the impugned award is reproduced hereunder for ready reference. Para 15 at page 61 paba. এই যোনটো মেইন প্ৰথম ৰিডটো কৈ আছো সেইটো ৰিডৰ para 15 quote unquote 15 16 17 18. Okay. Okay. Perusal of the perusal of the perusal of the aforesaid award, it is apparent that the labor court, after appreciating and reappreciating the evidences, has answered the three issues against the workmen. This court finds no manifest apparent error on the face of the record of the award. No. It is well settled law that a writ of certiorari is not available to correct mere errors of fact or of law unless the error is manifest and apparent on the face of the proceedings, such as when it is based on clear ignorance or utter disregard of the provisions of law, and a grave injustice or gross failure of justice has occasioned thereby. Reference is made to the decision of the apex court in the case of Surya Dev Rai versus Ramchandra Rai, reported in can one of you please give me the citation of Surya Dev? Because this is a Manupatra. Paragraph to check for you. Paragraph.
Lordship is 2003 supplementary to
2000
SCR.
reported in 2003.
Supplementary to SCR page 290.
Do you
This
have the
also is
SSC?
SSC also.
I think it should be there in
It's
SSC.
SSC also.
It's a
Lordship.
Vedika par loi lo ba, ha? Paragraph 31. Paragraph 37. 37.
In AIR it is 2003.
All right.
3044.
Reference is also made to the decision of the apex court in Radhesham versus so-and-so, reported in 2015, volume 3 SCR at page 197. Little paragraph to be simplified, huh? Viewed from this, viewed from the aforesaid angle, there is no view from this angle. WPC 6540 of 2018 is devoid of any merit whatsoever, and therefore the writ petition stands dismissed. In WPC 2996 2018, it appears that though in view of the findings in respect of issue number 1, 2, and 3, the Labor Court did not order reinstatement. However, directed compensation, however, awarded compensation to the workmen amounting to rupees 1 lakh by holding as hereunder. Paragraph 619 and 20 of the so and so is reproduced. Page 63, Baba. 19 and 20 of the judgment. Huh? It a repetition to Baba. It appears that the aforesaid that the compensation was awarded on the basis that no domestic inquiry was held by the management. It appears that the aforesaid finding of the labor court is palpably and manifestly erroneous, inasmuch as the workman being retired on superannuation, there was no occasion for the management to hold any domestic inquiry. And therefore, WPC, stop Korea. Therefore, the award dated so and so, so far it to the extent of direct, so far it relates to the issue number 4, right? Issue number 4.
No, it was never an issue. This
Issue- it
direction
was
was
not
not an issue.
No, issue number 4 is relief.
Relief.
So that is against issue number 4 only, I think. So, okay, to the extent of directing, awarding compensation of 1 lakh to the workmen by the management cannot stand, is set aside and quashed. WPC 2996?
Yes.
2996 of 2018 accordingly stands allowed.
This point.
Sorry,
Item number 11.
7 or 8. na? Yes, what is this?
This revision is against the judgment of a trial court.
Item number kiman?
11.
11. Hey, Tumichwa. That change for.
This revision is against the judgment of a trial court, which was affirmed by the appellate court, whereby, my lord, I have been convicted for the offense of bigamy under section 494 IPC, my lord. Lord, in 2000, my lords, 3/12/2004, my lord, an FIR was lodged by the first wife against the petitioner. Allegation is of demand of dowry as well as bigamy. And charges have been framed under section 494 and 498A. One thing I would like to point out, my lord, if charges could have been 494, there is a bar under section 198 CRPC. Because based on a complaint only, court can take cognizance. Since both 498A and 494 are there, so
What are the facts? What
Facts, my lord.
you submit later? First, let me have a grip of the matter.
on 3/12/2004, an FIR was lodged by the first wife, alleging that, my
The
lord,
judgment under revision, this is a revision,
revision, my lord.
is against that 27/7/11. Which is the judgment?
Judgment is 18/12/2006 of the trial
Why?
court.
What is this judgment?
Oh, this is the judgment, my lord, against the second wife, so-called second wife. There is a separate
Okay.
complaint case, and
Where
she
do
has
I get the judgment?
acquitted.
Where do I get the judgment?
Judgment is at page 17, my lord.
Page
Page 17.
17. Yes, please. Yes,
Allegation is of dowry demand as well as 494.
yes, read.
May I read the operative portion?
Yes, no, you read.
On 3rd December 2004, Dipti Rani Devi filed a complaint against her husband, Sri Bhupen Nath, before the Learned Court of Chief Judicial Magistrate, Gwalpara.
Who is the petitioner?
Dipti Rani Devi is the first. I am petitioner.
You are the petitioner?
Yes.
Dipti Rani Devi.
No, madam. I am the petitioner in this revision petition. Petitioner, that is the complainant. Dipti Rani.
Complainant. Here, the complainant is respondent. You are appearing for the respondent.
Yes.
Complainant.
Yes. So before the CJM inter alia alleging that her husband Bhupen Nath had subjected her to cruelty.
You are Bhupen Nath?
Yes. Demanded dowry of rupees 50,000 from her, beaten of her, and on 6/2/2000, it should be 2000, ma'am, her husband Sri Bhupen Nath married another woman, Sri Arati Nath, during the subsistence of his marriage with Sri Dipti Rani Devi.
So Arati Nath has also filed a case.
Against the Arati Nath, separate complaint was filed, and after.
By you.
No, madam. That first wife has filed 2 complaints against Bhupen Nath as
And
well as
Arati Nath.
she has been acquitted.
Okay.
In that case.
Okay, have you
The
finished?
Learned Chief Judicial Magistrate Gwalpara forwarded the above mentioned complaint to the officer in charge Gwalpara for investigation.
Go from here.
On receipt of the said complaint, the officer in charge of Gwalpara Police Station, treating the said complaint as an FIR, registered a police station case number 300/2004 under section 494 to 323/506 IPC and initiated the investigation. Ultimately, on completion of the investigation, formal charge sheet was laid before the court against the accused Bhupen Nath under section 498A, 494, 419 and 496.
498A is
Dowry demand, my lord, cruelty.
dowry.
Yes.
Cruelty.
Yes.
And 494?
4 is bigamy, my lord. Charges have been framed under
496?
496.
Charges have been framed against.
Framed under 498A
and
494. In the latter paragraph.
Yes.
The accused Bhupen Nath appeared before the trial court to face the trial. After furnishing copies of the documents referred to in section 207 and after hearing both sides, charges under section 498A and 494 IPC were framed against the accused. And the same on being read over to explain to him, he refused to plead guilty and claimed to be tried. The accused was discharged of offense under section 496 and 419 the IPC. Following points are required to be determined in this case: whether during the month of November 1997 and on several occasions thereafter, accused Sri Bhupen Nath subjected his wife, Sri Dipti Rani Devi, to cruelty with a view to force her to meet his illegal demand for payment of dowry, and thereby the accused committed offense under section 498A IPC. Whether on 6/2/2000, accused Sri Bhupen Nath, already having wife, Sri Dipti Rani Devi, alive, married one Arati Nath and thereby committed the offense of 494. The prosecution side examined 9 prosecution witnesses. They are as follows: Dipti Rani Devi, Harishan and so and exhibited the following documents. The accused was examined under section 313 CRPC, during which he totally denied the allegation of torturing Srimati Dipti Rani Devi and marrying Srimati Arati Nath. The defense side also adduced evidence of the following witnesses: 1, 2, and 3. I have perused the evidence on record very carefully and heard learned counsel for both the parties at length. Decisions and reasons thereof. But one thing I'd like to point out: under 498A, I have been acquitted. So 498A, I have been acquitted. So your lordship, kindly go to the paragraph 14. Starts from paragraph 14, but deal with only 490.
So you've been only convicted under 494 bigamy.
Yes.
Yes.
So from paragraph 10 to 13, it's about 498, and whereby I have been discharged, acquitted. So page 24, my lord.
Yes.
Reasons for 494.
Yes.
Paragraph 14, my lord. Now let us discuss as to whether the accused Bhupen Nath, already having a living wife, Srimati Dipti Rani Devi, married one Arati Nath and thereby committed offense under 494 IPC. PW1 has deposed that PW1 is the first wife, complainant, has deposed that.
Mr. Bora is not with you in this case.
No, madam. He's just assisting.
He's been very carefully
He was assisting.
observing you.
He is assisting me.
Yes, that's why I am asking why he is sitting back and not alongside. Yes.
Yeah. PW1 has deposed that she was married to accused on 28/1/1993. This fact has been admitted by the accused while deposing as DW1 as PW1. PW1 has further deposed that on 6/2/2000, the accused Rupenath married for second time one Aratinath at Paglatek temple.
Who's PW1?
One is the complainant, Dipti Rani Devi. PW5 is the priest. It ought to have been PW6, Melo, who is the priest of the Paglatek temple, has deposed that on 6/2/2000, he performed the marriage of the accused with Aratinath. He has further deposed that at the time of marriage, the accused stated his name is Bhuvaneshwar Nath. PW6 further deposed that marriage was performed as per Vedic rites. It should, my lord, this is a point to be noted, my lord. PW6 says that marriage was performed as per Vedic rites.
Yes.
What are the rites are performed? There is no indication. There is no
What is to be informed there? It's Vedic rights.
Vedic rites.
Then
I-
you see, I am exercising revisional jurisdiction. I cannot appreciate this evidence. The purpose of seeing this is to see whether there is some evidence or not. If there is some evidence, I'm not going to weigh those evidence.
There is a vital thing, my lord.
Correct.
Trial court has based on his finding based on the evidence of PW6.
Because he's the priest.
He's the priest.
He's the best person to say whether there is a wedding or not wedding.
But
He
my-
says as per Vedic rites.
Vedic rites, my lord.
Vedic
Supreme Court-
rites would be Arya Samaj maybe. We
That
don't
has
know.
to be spelled out, my lord, what the Supreme Court
Whatever
has said.
be it. Have you tried to discredit this witness during cross-examination?
Yes, my lord. Cross-examination, my lord, he has said only that as per Hindu rites, the
Then
marriage was performed.
He's clarified.
But my
What
lord,
remains?
I would
Mr.
like to
Kodita,
place a judgment of the Honorable Supreme Court.
judgments will have is contextual.
What
We
constitutes
will
a
have
valid
to
marriage?
apply them in the context of each case.
My lord, what constitutes
First you point out the error.
error, my lord?
What is the error? Hindu rites. Priest is examined.
Finding is that
How can this court ignore the evidence of the priest?
my lord,
Unless, of course, you had shaken his evidence.
yes, my lord. Kindly go through paragraph 18, my lord.
No,
There is the
let's
finding.
complete this first.
Yes. PW6 has also exhibited one marriage certificate as Exhibit 2. He has also deposed that Exhibit 2 was later on seized by the police, and on that day only, he came to know that the accused married for the second time in his temple. PW7 has deposed that she is the resident of Bapuji Nagar, and the accused purchased a plot of land in front of her house. She has further deposed that the accused has married one Deepa alias Aratinath and has one son named Bhargamnath. From his second marriage, PW7 also deposed that the accused Sri Rupenath lives in front of her house along with her second wife and son. The DWs have denied the factum of the second marriage. DW1 has also deposed that he has.
So PW7 has also given evidence.
7S says that they are only living together.
Whatever. The fact, you see, marriage part PW5 has already said. Now PW7 has not seen them getting married, so she doesn't know about that. So they're living. What is wrong? There is nothing inconsistent.
In 494, my lord, the prosecution has to establish both the marriage is a valid marriage.
As
a valid marriage, my lord. Then only section 494 will apply.
The priest has said that he has conducted the marriage as per Hindu rites. What more validity you want?
PW6 has not identified the second wife, my lord. To whom he contacted the second marriage.
Even assuming he has not said it is this particular lady, but he has said, and there is a marriage certificate, Exhibit 2. What is the name in the Exhibit 2?
Exhibit 2, his name is Bhuvaneshwar Nath, my lord.
No, that is the name of the accused because he have stated that the accused stated his name as Bhuvaneshwar Nath.
Yes.
And what is the name of the girl?
Aratinath, my lord.
Then
she was not identified by the PW6.
The certificate is issued by him on the basis of the information provided.
Whether he is a priest.
He is not going to look into their Aadhaar cards and put their names.
Since So the PW6, whether he was a competent priest or not, it is also questionable, my lord, because.
Have you raised this?
Yes, in the cross examination, he could not produce any
But the-
document to show that
But
he
you
was
see,
the proof. He was the priest.
the trial court has not accepted that part of your submission,
Yes.
and this court doesn't find any patent error, manifest error.
Well,
In the findings of the court, there is evidence. On the basis of the evidence, the trial court have held the offense of bigamy to have been proved. What is wrong in it?
the trial court has finding is
In
that
revisional jurisdiction, even if there are two views, this court is not going to set aside the judgment of the trial court.
if your lordship go through the
This is not appeal.
finding of the trial court is at paragraph 18. Trial court has assumed that the necessary ceremonies are performed, whereas there is no evidence.
There is evidence, PW5. Why are you forgetting? You're repeating.
It's
Repetition will not help your case.
But can I go through
There is no doubt in the mind of the court that that part of the evidence doesn't indicate that there is a valid marriage.
Yes.
Because in cross-examination, he clarified.
Well, merely
Where do I
saying
get the cross-examination?
the evidence. It's in vernacular.
Gaurav, can you please find out the cross-examination of the priest in the trial court records and just highlight, and you can read it out to me.
Yes,
Is it in the vernacular or English?
Vernacular.
it's in the particular.
Please read it out.
Yes. I'm reading the cross part,
Yes, yes. You can actually read the entire part.
entire part. actually.
Let's just have a look at it.
PW6 of it. PW6.
Six, na, Mr. Kodita?
আচ্ছা পদক্ষেপ মই চিনি পাওঁ PW6 the priest
Yes.
yes পদক্ষেপ মই চিনি পাওঁ যোৱা 6-2-2000 চনত পদক্ষেপৰ লগত আৰতি নাথৰ লগত মই বিয়া কৰাই দিছিলোঁ তেওঁ বিয়াৰ সময়ত নিজৰ নাম ভুৱনেশ্বৰ নাথ বুলি কৈছিল বিয়া হোৱাৰ পিছত দিনা
দিয়া পিছত দিয়া প্ৰমাণ
পিছত
You have it with you? You have it with you?
Yes.
Then you read if you can read from yours.
বিয়া হোৱাৰ পিছত দিনা কলম কি প্ৰমাণ ল'ব হয়
প্ৰমাণ পত্ৰ
প্ৰমাণ পত্ৰ দিয়া হয় পদক্ষেপ ভুৱনেশ্বৰ লগত
Podokhe means the accused.
ভুৱনেশ্বৰ নামেৰে দিব্যা বাচনি আৰতি নাথৰ বহি বিয়া বৈদিক নীতিৰে হৈছিল As per
Vedic rites.
Yes, Vedic rites, the marriage has been taken place. আৰতি নাথক দেখিলে মই চিনি পাম I can recognize.
Vedic rite probably means Arya Samaj,
Yes, Lordship.
isn't it?
Yes. That's Sat Peri Lordship.
Correct, correct.
Yes. পিছত পুলিচে exhibit number 2 জব্দ কৰে সেইদিনাহে মই গম পাওঁ যে ভূপেন নাথে আমাৰ মন্দিৰত দ্বিতীয় বিবাহ কৰাইছিল বিয়াত হিমেশ দাস জীৱন দাস বনমালী দাস আৰু ৰত্নাকৰ দাস সাক্ষী আছিল
Have they been
They are
examined?
not examined.
Yes. 6-2-2000 তাৰিখে মই মই জনা নাছিলো যে ভূপেন নাথ আগৰে পৰা বিবাহিত হয়
Okay.
This is the examination
Cross.
instead. The cross part is Baglartit Mandir Shiva Mandir হয় বিয়া বায়ু
বেদ মতে
বিয়া বাৰু বেদ মতে হয় পদক্ষেপৰ বিয়াত মালা বদল হোৱা নাই যজুৰ্বেদৰ ৰচয়িতাৰ বিষয়ে মই নাজানো বিয়াত উপস্থিত সাক্ষীগণক মই এতিয়া চিনি নাপাম মই পুৰোহিত হিচাপে পোৱা নিযুক্তি পত্ৰ আজি আদালতত অনা নাই এইটো সত্য নহয় যে মই ভূপেন নাথৰ দ্বিতীয় বিবাহ পুৰোহিত নাছিলো It's not the fact that I am not the
I've understood.
Yes, Lord. এইটো সত্য নহয় যে ভূপেন নাথে ভুৱনেশ্বৰ নাথ হিচাপে বহি চহী কৰা নাছিলে এইটো সত্য নহয় যে ভূপেন নাথ আৰতি নাথক বিয়া কৰোৱা নাছিলে এইটো সত্য নহয় যে হিন্দু ধৰ্মৰ আচাৰ আৰু ৰীতি মতে বিবাহ হোৱা নাই
So that suggestion has been denied.
Remain lordship on the material
Yes.
but he's remained consistent
Yes.
so that cannot be
Mr.
discussed.
Kolita,
My lord may kindly see Hindu Marriage Act, section 7.
you read.
Ceremonies for a Hindu marriage. A Hindu marriage may be solemnized in accordance with the customary rites and ceremonies of either party thereto, where such rites and ceremonies include the Saptapadi, that is to
Includes
Saptapadi, that is taking seven
Seven
steps
steps.
by the bridegroom and the
when
bride.
such customary rites include.
Includes.
Now, we don't know whether Vedic rites would include or not include.
But there has to be some ceremonies. There has to be.
That he has said there is a ceremony. He said my
No, my lord, he has not
Hindu.
said anything.
He have said it as per Vedic rites. Biya korwa hoise. He
That
have
is
said
not
it.
enough, my lord.
He may
To-
not have elaborated. It may not have been elucidated from him. In your suggestion, you have suggested he denied.
My lord, law says that that is
When he has,
specifically to be proved.
it will be assumed that it has been done as per the custom because he have mentioned the word Vedic rites.
Vedic rites. But what are
So
the
it
rites?
will be assumed that it is as per the Vedic rites. There is nothing to indicate that it was not done. You are only trying to say that Vedic rites, however, he has not elaborated. Because he has not elaborated, therefore section 7 is not fulfilled. This
Unless
is what
and
you are
until-
trying to demonstrate. Sorry,
My lord, may
that's
kindly,
not an error on the apparent.
I would like to rely upon the judgment of the Supreme Court, my lord.
Yes, please. The facts better be same.
What constitutes a valid marriage to
That's okay.
convict a person
That's
under
okay.
bigamy, my lord?
You see, as per the custom, if 7 steps is required, it is mentioned in that.
Yes.
Isn't it? And here, have you made that suggestion that the 7 steps has not been taken?
No.
You have not given that suggestion. Then how
That-
can you take reliance of that case of the Supreme Court? Where is the suggestion from you?
Since evidence doesn't disclose anything.
Where is that suggestion from you? Because in evidence, he have clearly said, as per Vedic rites.
Yes.
Mr. Kaman, is the view that I am holding, is that correct? Because they have,
Yes, my lord.
it's
I
a,
think so, my lord.
only as a, because since you are one of the,
No, that's not that way. My lord, we try to be.
I would say the encyclopedia for criminal law.
Yes.
The priest has said that the marriage he's conducted the marriage as per Vedic rites.
Right.
And during cross, one suggestion came that whether there was some exchange of garlands, which he said no.
No.
That's all. And there was a suggestion which about whether it was done in term as per the Hindu thing or not. That also he said, he agreed that it is as per Hindu. He denied that suggestion. When they suggested that it was not done, he denied. Now an argument is trying to be placed before this court in a revisional jurisdiction that the 7 steps, which is an essential step, was not taken. How can this court at this stage, while exercising revisional jurisdiction, go into that? In fact, there was no suggestion. Had there been a suggestion, one could have understood. Now, the moment he has said that it was done as per Vedic rites and he's denied the suggestion not done as per the Hindu rites, it is assumed that he's done it. As per that means there is a valid marriage.
Suggestions are normally given, my lord, if we cannot demolish it in a
Correct,
proof.
correct.
So that we put it as
Something
suggestion
is there,
so that
some
we can
foundation.
argue from it.
And it appears that you have taken this ground, so some
Yes,
foundation is
That's
there.
your case.
Correct. Correct. This point was never, it was never suggested. So now at this stage, and this is
That
revision.
point cannot be probably.
Because there has to be a
That's the
apparent
law as
error.
I understand.
Yes, this is how I understand also.
Madam, may kindly go through
Thank
the
you.
judgment.
Thank you for your assistance.
Madam, may kindly go through the judgment.
Yes, I will go through your judgment, but you see, I can distinguish that judgment simply by saying that you have not taken this point of about the 7 steps, which you are now trying to claim.
My lord, prosecution has to establish
Your-
that, my lord.
your Prosecution has established, Mr. Kolita. What more the prosecution needs to establish? Vedic rights.
Vedic rights is not enough to convict a person under bigamy, my lord. That is my submission.
Yes, appreciated. You are entitled to make your arguments, fully appreciating your arguments. But
2025 2 SSC, my lord. Para
2000?
15. 25 2 SSC. So let
yes,
us.
paragraphs 15,
15,
18, 35, 37.
Yes.
Yes.
Kindly go through. Para 15, my lord. Section 7 of
Yes.
Section 7 of the Act reads as under ceremonies for a Hindu marriage. A Hindu marriage may be solemnized in accordance with the customary rites and ceremonies of either party thereto. Where such rites and ceremonies include the Saptapadi, that is taking 7 steps, the marriage become complete and binding when the 7th step is taken. Section 7 of the Act speaks about ceremonies of a Hindu marriage. Subsection 1 uses the word solemnize. The word solemnize means to perform the marriage with ceremonies in proper form. Unless and until the marriage is performed with appropriate ceremonies in due form, it cannot be said to be solemnized. Further, section 2 of the 7 states that where such rites and ceremonies include saptapadi, taking 7 steps by the bridegroom and the bride jointly before the sacred fire, the marriage becomes complete and binding when the 7th step is taken. Therefore, the requisite ceremonies for the solemnization of a Hindu marriage must be in accordance with the applicable customs or uses, and where saptapadi has been adopted, the marriage becomes complete and binding when the 7th step is taken. Remember, where a Hindu marriage is not performed in accordance with the applicable rites and ceremonies, such as saptapadi, when included, the marriage will not be constituted as a valid marriage. In other words, for a valid marriage under the Act, the requisite ceremonies have to be performed and must be proof of performance of the said ceremony when issue arises and controversy arises. There has to be a proof of the ceremonies, my lord. Unless the parties have undergone such ceremony, there would be no Hindu marriage according to section 7 of the Act, and mere issuance of a certificate by an entity in the absence of the requisite ceremonies having been performed would neither confirm any marital status to the parties.
You're
nor
right.
establish-
If this was a case where only that marriage certificate would have been given,
Yes.
this court would have been with you.
Right.
But here there is something more. The priest have deposed that there was a marriage as per the Vedic rites, which he performed.
Well, what
And
are
that
the
part of the evidence is not
performance-
shaken.
but performance of that ceremonies has to be spelled out.
Where is it said it has to be spelled out, Mr. Kolita?
That it says
Which law says that it has to be spelled out, only then it can be assumed. When in the evidence he have said it, it is as per Vedic rites, and there is nothing on your part to show that it has not been done or these steps have not been done. Why should this court unnecessarily assume something which is not there? There is nothing to disbelieve the priest who has said that he has performed it as per Vedic rites, and to that extent he has issued a certificate. That is all.
whether the
And
certificate
our PW7 have said that they are living together. It's a fact that you are living with that other girl. That is also a fact. It has come on evidence.
My point is that, my lord, unless there is a proof of this, that is my
All
point.
right.
Your lordship got me.
That is noted.
Then
Anything else?
Para 18, my lord, can you?
Yes.
The perusal of the marriage certificate produced in the instant case along with the application file under so and so states that marriage between the parties has been solemnized according to Vedic rites. The certificate issued by so
Hindu Vedic rites.
Hindu Vedic, like the present case, my lord. The certificate issued by Vedic Janakalyan Samiti in the absence of any indication as to the rites and customs that were performed and as to whether the requirements of section 7 of the Act were complied with would not be a certificate evidencing a Hindu
Here,
marriage
was
in
there
accordance.
any evidence given by the priest in this case?
Evidence
In this
yes,
case,
sir.
in the decision that you're trying to rely, here,
No,
then, but in the case in hand, there is evidence of the priest. How can the court ignore that part? That is why I told you. Had it been a case where only the certificate was there,
yes.
definitely this court would have been with you. But the evidence of the priest is there. It is a deposition on oath. How can that be ignored?
Yes. But he's a priest or not whether he's a
Sorry,
Christian priest or is a
not at the revision stage.
my lord. Another judgment, my lord. 2024 8 FCC. Para 14, my lord. This is under 494.
What were the facts in Doli Rani?
Dorelani's fact is, my lord,
It's a civil matter.
yeah, it was a divorce petition was filed, my lord, and ultimately they have filed a joint petition before the Supreme Court. And while deciding that their validity of their marriage, Supreme Court has laid down the certain observation.
Yes, which is the next case?
2024 8 is to see, my lord. 706. There are 14.
Para
14, my lord. The essential ingredients of offense under 494 IPC, as explained by this court in Gopal Lal versus so-and-so, are that the essential ingredients of this offense are that the accused spouse must have contracted the first marriage, that while the first marriage was subsisting, the spouse concerned must have contracted the second marriage, and both the marriages must be valid in the sense that the necessary ceremonies required by personal law governing the parties have been duly performed. In this case, my lord, ceremonies, there was no ceremony was performed, and merely saying as per Vedic rites doesn't include the ceremonies have been duly performed.
Yes.
That's
What
the
is-
judgment of this
what
Supreme
is
Court,
the-
1965.
The other one? On which points?
The solemnization of a valid marriage, my lord. When a marriage is said to be solemn, because section 17, if you see the section 17 of the Hindu Marriage Act, says, my lord,
But right, according to you, it will be solemnized only on performance of the ceremony.
yes, section 17 says 494 will be attracted when there is a valid marriage. The factum of second marriage has to be proved by of adducing evidence regarding the performance of the ceremonies. What are the, whether there was a sacred fire, whether taking 7 steps, nothing has been spelled out. So, my lord, on this count, my lord, my submission is that I may be given the benefit of doubt, my lord. Prosecution has failed to establish the factum of second marriage by adducing evidence. In 1965 judgment, my lord, I would like to rely on para 5.
3, 4, 5, 12, 13.
Yes, C45. Married. Whoever having a husband or wife leaving marriage in any case in which such marriage is void by reason of taking place during the life of such husband or wife shall be punished with imprisonment of either discretion for a term which may extend to 7 years and shall also be liable to be fined. Prima facie, the expression whoever marries must mean whoever marries validly, and whoever marries and whose marriage is a valid one. If the marriage is not a valid one, according to the law applicable to the parties, no question of its being void by reason of its taking place during the life of the husband or wife of the person marrying arises. If the marriage is not a valid marriage, it is no marriage in the eye of law. The bare fact of the man and woman living as husband and wife does not at any rate normally give them the status of husband and wife, even though they may hold themselves out before society as husband and wife, and the society treats them as husband and wife. Apart from these considerations, there is nothing in the Hindu law as applicable to marriages till the enactment of a Hindu Marriage Act 1955, which made a second marriage of a Hindu male during the life of his previous wife void. Section 5 of the Hindu Marriage Act provides that a marriage may be solemnized between two Hindus if the conditions mentioned in that section are fulfilled. And one of those conditions is that neither party has a spouse living at the time of marriage. Section 17 provides that any marriage between two Hindus solemnized after the commencement of this act is void if at the date of such marriage either party had a husband or wife living, and that provisions of section 494 and 495 IPC shall apply. Accordingly, the marriage between two Hindus is void in view of section 17 if conditions are satisfied. The marriage is solemnized after the commencement of the act. At the date of such marriage, either party had a spouse living. If the marriage took place between the appellant and Kamalabadi cannot be said to be solemnized, that marriage will not be a void by reason of section 17 of the act, and 494 will not apply to such parties to the marriage as had a spouse living. The word solemnize means in connection with a marriage to celebrate the marriage with proper ceremonies and in due form. According to the Oxford Dictionary, it follows therefore that unless the marriage is celebrated or performed with proper ceremonies in due form, it cannot be said to be solemnized. It is therefore essential for the purpose of section 17 of the act that marriage to which 494 applies. Same thing, madam.
Okay.
So we are of the opinion
Point
that
of multiplying it with decisions. It's the same point.
yes. My point is that, madam, unless and until that ceremonies are performed, it
Noted,
is not a valid.
noted, Mr. Kalita.
That is my case.
That's all? Yes.
I am for the private respondent. Both the court below has categorically stated that bigamy is 494.
This is a
Religious solemnity as
appellate court judgment is at what page?
What?
Appellate court judgment is at which page?
57.
Page
57.
Appellate court judgment has a contrary judgment passed by the trial court.
57.
Yes.
Appellate court, there was an prayer for adjournment on that date of hearing, which was rejected.
Appellate court judgment not annexed.
Yes, appellate court. 57. Para 58, my lord, goes to para.
A son is also born.
Appellate court judgment page 57. Appellate court judgment.
Yes, yes, page 60. Page 60, read para 8. Mr. Kolita, please take your seat. You are finished.
Not.
Sorry, Mr. Nath. I stand corrected. Yes. Para 8.
Para 8. Yes. After going to the evidence of the contracting parties, the admitted position is that in the Goalpara Civil Hospital, one child was born on 22/1/2001 and father name was recorded as Bhupen Nath. Exhibit 2 marriage certificate shows that one ROT Nath was married with one Bhupendra Nath, Bhubaneswar Nath on, because it is PW6 has stated that he has given the undername at the time of solemnizing marriage in Paglato temple. As per Hindu customary law, the priest of the temple PW6 on its Chakraborty has categorically stated that it was accused Bhupen Nath who impersonating as Bhubaneswar Nath and had married Arati Nath as per Hindu customary law on 60/2/2000. PW7 Padmavati Devi has also categorically stated that the accused Bhupen Nath has remarried Arati Nath and they lived in the house in front of her house, and one male child was born out of this wedlock, and in his name
Are you carrying the case of Gopal Lal?
Hello?
You have it, Mr. Nath?
Yes.
Does it in that decision, Apex could have said even the second marriage, even if it's void, 494 shall have no application.
No, in section 494, form of marriage has not been defined. Only marriage.
One second. You have Gopal Lal, sorry.
Yes, sir, I have.
You're not carrying it.
I'm reading your lordship is talking.
No, you're not carrying the decision of Supreme Court in the case of Gopal Lal.
1979.
No, I know.
That is in favor. In the head note, it is said, but where is it? Yes, para 5. What section 17 contemplates is that the second marriage must be according to the ceremonies required by law. If the marriage is void, its voidness would only lead to civil consequences arising from such marriage. Section 7 makes it absolutely clear that the provisions has to be read in harmony and conjunction with the provisions of Section 494 of Penal Code. Section 17 clearly provides that provisions of Section 494, 495 of the Penal Code shall apply accordingly. In other words, though the marriage may be void under Section 17 by reason of the fact that it was contracted while the first marriage was subsisting, the case squarely falls within the four corners of Section 494, and by contracting the second marriage, the accused incurs the penalty imposed by the said statute.
Thus, the combined effect of 17 and 494 is that when a person contracts a second marriage after the coming into force of so-and-so, while so-and-so the commits of bigamy, this matter is no longer resident so-and-so. So even if it is void, it shall, 494 shall have no. It is mentioned here, if the marriage which took place between the appellant cannot be set and so cannot be said to be solemnized, that marriage will not be void by virtue of section 17 and section 494 IPC. And section 495 IPC will not apply to such parties to the marriage as had a spouse living. What does it mean? It's slightly complicated. Because towards the end, if you say, it says the voidness of the marriage under section 17 of the Hindu Marriage Act is in fact one of the essential ingredients of section 494. Because the second marriage will become void only because of the provisions of section 17 of the Hindu Marriage Act. Because the first marriage is there, you see. In these circumstances, therefore, we are unable to accept the contention of Mr. Mullah that the second marriage being void, section 494 will have no application. So that is rejected. That even if just because the marriage is void, doesn't mean that section 494 will not be attracted, because that is criminal consequence. So this also goes against you.
In other words, my lord, in offense under bigamy, both marriage has to be proved by using evidence.
No, you are right.
First
But you
step-
see that those decisions that you are relying are also in the context of civil matters, divorce and all, right? This is criminal. But be that as it may, as I have said, indicated, I don't find anything, any error in or infirmities in the decision of the appellate court, nor in the. All right, Chief. Anything you want to add?
Policy issue, that is issue of the second marriage is concerned. That is proved by DW6 as well as DW7 and also by DW3. I can tell you the statement of DW3.
Where is that?
I have flag mark.
Flag mark where? Here? TCR. TCR can you put it? Just 90K?
DW3 happens to be the lordship. As a lordship.
No, it is not here.
It's 71.
Page?
71.
I think this is part of the.
That is one second. LCR, please, sir. Please.
Oh, 8. No. Email TCR. Is it available with you, DW3?
My lord.
Yes. Please give it to Ms. Bora. Rupak.
So DW statement is what?
One second.
DW three.
Yes, please.
Yes, Lordship. Lordship, may I read the entire?
No, relevant.
Relevant question by the courts, Lordship. আপোনাৰ ল'ৰা ভাৰ্গৱক কেতিয়া জন্ম হৈছিল আৰু ক'ত জন্ম হৈছিল?
That is ROT Devi.
Yes, no, yes, ROT Devi, the second one. মোৰ ল'ৰা 22/2/2001 তাৰিখে গোৱালপাৰা চিভিল হস্পিটেলত জন্ম হৈছিল। আপুনি গৰ্ভধাৰণ কেতিয়া মই গৰ্ভধাৰণ কৰাৰ পিছত গোৱালপাৰাত ভাৰ্গৱৰ জন্ম দুদিনৰ আগতে হস্পিটেলত আপুনি আপোনাৰ স্বামীৰ নাম কি বুলি কৈছিল? মই মোৰ স্বামীৰ নাম ভূপেন নাথ বুলি কৈছিল। She herself admitted, Lordship, that her husband's name is Bhupen Nath.
Okay.
My lord, to make it a bit further, let me go through some.
Further?
Any judgment
Why?
regarding that issue?
What judgment you want to go through, Mr. Nath? It's a 2011 matter.
Yes.
I don't think anything is there. I can dictate it right now. Everything
Yes,
is fresh in my mind.
My lord, the second wife, he has been acquitted. So
Otherwise,
Where in
I'll
this-
dictate it tomorrow at 10:30. I can give you time till 10:30.
well,
You have time till 10:30 to
if the
change
second,
the mind of the court.
that can be done. One thing, my lord, if the second wife is acquitted, in the allegation is I have
That I am not concerned right now. What I am concerned are these two findings of the trial as well as the appellate court. I do not
Finding
see
is
any
based on-
legal infirmities.
assumption, my lord.
I don't see any legal. They are not assumptions, Mr. Nath. You see, I'm giving you time not for repeating what you have, what have you submitted. Only in case you get hold of some decision of the apex court, then all right. But it has to be on the point. The facts on the context of this case, not
Yes.
simply, I don't want, you have already given 3 decisions. Please don't multiply on the same point.
Yes.
There will be no use. One decision in one point is sufficient. For the points that you have argued, you have already given the decisions. However, against that decision which we just saw right now, that Gopal Lal, that you can have a look at
Ma'am.
and make your submissions only on that. Hardin part, no, arguments concluded. Relist tomorrow for delivering judgment in open court at 10:30.
Deeply obliged.
None appears for the petitioner on call, relist. Did your,
I have gone through my date may fix
did your,
on 10.
10.
Adjournment number 13 and 14.
No, please, Your Lordship. I'm appearing as a legal aid counsel in this instant appeal, Your Lordship.
For the appellant,
Yes, Your Lordship.
how many witnesses?
Of the total 27 witnesses.
27.
Yes, Your
I
Lordship.
think we can start on another date then.
Lordship. Moreover, Lordship, if I may, because this appeal was preferred by the private appellant at the onset. Thereafter, they stopped appearing. That is why I was appointed. And moreover, Lordship, if Your Lordship peruses the order, he's been convicted. They have been convicted under 304 Part B and 249. And the imprisonment is for 4 years. And the
Undergone.
judgment is of 2811, Lordship, 2011. So that was what was pointed out on the last occasion by the Honorable Court. And accordingly, the learned public prosecutor also asked about the safe effect. So if Your Lordship may take some necessary step with regard to this, because supposedly they were not also on bail. They were sent undergoing the
To
immunization.
find out what, whether he's undergone the,
Yes, yes.
there was no fine, only
Lordship, no fine, no fine. This default of 2 months or.
that if, even if suppose he's undergone.
Yeah.
And he has a statutory right for appeal.
Right.
Now, if suppose we find that the appeal has substantial merit, then why? Because there will be a stigma always there.
Lordship, as a lordship, as a lordship,
What do you say?
as a lordship.
Stigma will always be there.
Yes, madam.
This
That
is
may
a
be the-
statutory right.
As a lordship.
I don't think that is of any relevance,
Yes.
isn't it?
Lordship,
When?
as per the convenience of this court, lordship.
It will next Tuesday, did you?
Obliged, lordship.
Due to paucity of time or release Tuesday date?
Item number 17.
Yes, Mr. Bhatti, this is.
Yes, my lord, this is for passing of the FIR. My lord, at the initial stage, my lord. At the initial stage, very.
406, 420, 506.
Yes, sir.
Where is the FIR?
FIR, your lordship will find at page 45.
40?
5. Yes. Where
Complaint case. Complaint
initially
case.
the complaint was filed. Later on, the complaint was transferred to police, police for investigation, and accordingly, police registered the Chayanga police case number under section 379, 406, 420, 506, 120, B and 34, my. This is the complaint. May I read it, my lord? It starts at page 46. That the complainant is a citizen
Read
of-
from para 3.
Yes, ma'am. That the decade ago, complainant had an affair with the accused number 3 when the complainant was pursuing a study at Haryana. That even during the starting of love affairs between the complainant and the accused number 3, the accused number 3 desperately used to take undue privileges from the complainant. She even without a reasonable cause, he used to take money from the complainant on a promise that she will return the same amount, but never bothered to return the same. That somewhere in 2005, 2006, the father of the accused number 1 and 3 got several attacks, which resulted him to paralysis. The accused persons during this period found emotional.
Complainant is the boy. Complainant is the boy.
Boy. Resulted him
And complaint.
supplied with 31.
Mr. Kaman, you are appearing for the complaint.
My lord, I'm for the other two, my lord. But unfortunately, my
You are
lord,
for the other 2 means?
no, my lord, we are same team, my lord. The thing is that, my lord, that we are supplied with the copies of till page 31, my lord.
Sorry?
Page 31 only has been supplied to
Oh,
us. at the
remaining
time of
copies have not been given to you.
No, only 31. My lord, no, the case is before you, sir.
2014 matter.
My lord, this case is pending since. No, I'm ready.
No,
But again,
Mr. Kaman, have you not taken this objection earlier?
No. Today, my lord, actually, when we are going to that part, my lord, we have taken it. I'm not objecting to it.
I'll have.
Even though I'm,
talked,
no, my lord, let it have it, my lord.
We can proceed.
Yes, my lord. Only thing is that, my lord, if arrangement can be made only, my
Mr.
lord.
Bhatti, you please ask someone to make those copies available.
Till 31, we have
My
it, my
lord,
lord.
just it may not be possible on my part to make.
No, after completing today.
Let it come my
Thursday.
day after tomorrow.
Thursday, day after tomorrow.
Yes. I'm ready today also, provided after his thing, he may give us.
Please give it to them today so that they have substantial time to. Right now, it's the last thing
Yes.
to make photocopies.
Yes, all the copies are how many?
Mr.
There are up to 31.
Come on, there are senior counsel assisted by. Assisted by. Come on, assisted by. Huh? PD.
P. Dev Chaudhary.
Dev Chaudhary. P. Dev Chaudhary, learned counsel for the respondent number.
Two, my lord.
For the
Stage is
respondent
respondent
number
one, my lord.
points out that points out that few pages in the appeal in the criminal petition is missing. Mr. O.P. Bhati, learned counsel for the petitioner, assures that the missing pages shall be furnished today itself. Relist Thursday.
Item 18.
32 for.
Mr. Biswas, your petition is your with. Okay. Yes, Mr. Agarwal.
It's a passing of a complaint. Well, it's a fight between the sisters and brothers, basically.
Where is the other side? Petitioner in
Other
person.
side, my lord, they are not appearing with, basically, from.
Today, I thought I've seen one person in civil sitting in the back. No, Aji Asil Adjournment.
He's an advocate also. That respondent number 2.
We'll have it on another date.
All right.
Heard Mr.
Not
P.
only thing.
Agarwala, Leonard Senior Counsel, assisted by Neo Leonard Counsel for the petitioner. Also heard MS S.H. Pora, Leonard APP for the state respondent. Despite the name of the petitioner who is appearing in person for despite the name of the respondent number 2 who is appearing in person is being reflected in the cause list. However, on call there is no representation. Relist next Tuesday.
Milord?
Next Tuesday.
Tuesday will be difficult.
When?
Either on Thursday or Milord May first week, Milord.
May first week did you?
No first week date.
First May.
Let registry intimate the respondent number 2 the date of the next date of listing. Yes. To email through WhatsApp message.
1st of May.
Item 19.
Item 19 to time list. Out of court, what happened?
Lordship, they have said, Lordship, the payment has been made today, Your Lordship, but I have not received the document, Your Lordship.
It is submitted at the
Monday,
bar
Your
that
Lordship.
the payment perhaps has that the payments have been
Made, Your
made today.
Today, Your Lordship.
However,
the document has not been received.
however, the document have not been received by the learned counsel
Petitioner, yes.
by the petitioner.
On
Stop.
Monday, Your Lordship.
Released Monday did not.
Oblige, Your Lordship.
24.
Oblige.
Item number 26.
26. Yes, Ms. Saikya, you are the Namikis for R2.
Lordship.
Yes. What is this?
Milord, conviction under POCSO Act, Milord, for 7 years.
How many witnesses?
Milord, total 6 witnesses.
Thursday की बार fix करो इसमें. Ketas. Atas. Thursday. Thursday. Due to paucity of time or Thursday?
On 20th, Lordship. On 2
Yes.
days. Deeply obliged.
Itu kuat apa ini?
Or 21. अब रिविजन हो गया रिविजन हो गया रिविजन में लिया देखो कोनो नाय पे नाम के से है तो हर तो ये बात है सेक्रेटरी दिला उसको सेकंड विकेट दी थी 10 तारीख को itu 21 itu. Itu tadi mulai jadinya mulai file naik ini naik itu semua double tahu sih. Itu double tak kena kau. Itu tak itu mun beli file bagi di sini, na? Beli file masih di mana? Oh, bukan file lu masih. Kamu number dalam sosmed. Yes. Tip tidak ditulis. Siapa ini? Ini main file biasa. Itu tuh original loh. Nanti kalau certificate itu biar tak gitu loh. Ras itu dulu. Satu seri. Dari mana dah? Ini udah kita hari di mana? Phone number.